So I've looked at those documents. They seem to be in pretty similar form, one under the Judiciary Act and one under the Charter. There is nothing in the Charter that precludes me from going on to hear the matter, notwithstanding the service of the document as I read the Charter, but there is that clause in the Judiciary Act that is engaged, if it's established, that there is a matter arising under the Constitution or involving its interpretation. What is the rationale for which it is said that the proceeding should be adjourned?
Yes, Your Honor. If I could just make a couple of preliminary points, if I may.
Yes.
Firstly, Your Honor, I raised this Thursday. I do have hearing issues that causes me to be anxious in regards to answering questions, simply because sometimes I get the whole question, sometimes I get part of the question. Therefore, I'm anxious because I don't have great confidence in my hearing. I have 2 hearing aids which I've explained to Your Honor, and that does make it a little bit difficult for me in this role of presenting the matter.
I should say, Mr. Ansell, I've not noticed any occasions where you have not heard and understood what I have said. But if you don't hear something I say, please do let me know.
Certainly, Your Honor. But, as I said, it's more the anxiety I experience, and try to make sure that I've heard the question correctly.
All right.
And then that, combined with the fact that I do suffer from hypertension, certainly makes me nervous in respect of this, because I'm certainly not a trained advocate. Your Honor, in respect of our current application that we're talking about, you would note that it's a joint application.
Yes.
On behalf of myself, Mr. Kuksal and Ms. Zhu, we have all signed the document. Whilst Ms. Zhu and I collaborated in the preparation of the document, Mr. Kuksal did the majority of research in respect of the document, and he would be far more illuminating in putting forward our case, our joint case, because it is a joint application not necessarily linked to the one matter, and that would be, I think, a fair and reasonable situation in respect of our joint positions. So certainly we've requested Mr. Kuksal be able to address the court on this particular issue, Your Honor. And also, I just point out in regards to the Charter of Human Rights and Responsibilities, there are SS 24 and 25, which basically state the court should make reasonable accommodation for people in both civil and criminal matters. And especially this is now deemed to be a criminal matter. I think in all fairness it's a joint application that Mr. Kuksal be allowed to address the court.
So what are those sections 24, 25? Section 25 says, you're presumed innocent until proved.
I'm sorry. Pardon, Your Honor. The question of due process.
I set this down for hearing of the claim against you, but this appears to be an application to stay the entire proceeding. It seems to me, Mr. McAuliffe, that Mr. Kuksal is one of the moving parties in that application. He should be given an opportunity to present it. He is not just seeking to have the proceeding against Mr. Ansell stayed, insofar as it concerns Mr. Ansell, but also the proceeding against him. Now the timing of it is unfortunate.
Indeed, yes.
That it happens at, it's now 11:45 on the day that we're meant to be going against Mr. Ansell. Mr. Kuksal, have you got any?
No.
What do you say about that? Anything?
Your Honor, I accept to the extent that the application is on behalf, or Mr. Kuksal makes it also on his behalf, and the other defendants join in it, to temporarily stay the proceeding. If that is the application, then I don't oppose Mr. Kuksal being heard on it.
Right, no.
For himself, of course.
Thanks. Yes, Mr. Kuksal. How long do you think you'll be to develop the argument?
Well, Your Honor, it depends on...
No.
What Your Honor has.
Suppose I don't ask questions. How long will you be?
I'd say 45 minutes.
All right, Mr. Kuksal, tell me why the proceeding should be stayed.
If I may just make my way to the lectern.
Sure.
Okay. So, Your Honor, I'd like to start with addressing the court about 2 issues that the court just raised, and I respectfully disagree in relation to that. And the first matter is whether or not I would have had a right to address the court.
Mr. Kuksal, I'm letting you address me. Don't waste time on that.
No, but it's about the other matters. It's my... Firstly...
You've got 45 minutes, Mr. Kuksal, so bear that in mind.
Yes, Your Honor, I know that. But that was contingent on no interruptions, respectfully.
Yes.
So firstly, in the judgment that Your Honor gave on Friday, there is a misapprehension of law. In particular, when I was seeking an adjournment, I had advised the court that I was not in a state to present the case, and I did not have any documents in front of me, and that I was addressing the court off memory. I am quite familiar with the sections of the Uniform Law, and in that confidence I had, without checking, referred to S14, when I had intended to refer to S13 of the Uniform Law. In any event, I had explained what the section was, and how it was sought to be relied on. In your judgment, Your Honor, you addressed why S14 was literally inapplicable. In my personal view, I think that was dishonest. I don't represent the other two defendants in saying that. In any event, whether it was dishonest or not, it was at the least a misapprehension of the law which I may have contributed to, but it is no reason for the court not to give effect to the law, which is that if there's any determination made in relation to Mr. Ansell, it affects all of us. Besides that, because we have not been removed from the proceeding, any matter that is decided in these proceedings, the court must hear us about anyway. So unless the court stays the proceeding in respect of us, we will have a right to address the court in respect of any determination in this matter. That is the law of the land. The second matter in respect of which I want to offer clarification is that it is both under the Charter and under the Constitution that the court is prohibited from acting further, unless the Attorney General has been given an opportunity to intervene, and that is irrelevant of the fact that the Judiciary Act is more emphatic in this respect. And, in support of that, I will rely on two legal principles. The first is the principle of legality, and I refer to, also, the authority of Condon v. Pompano, to which I have previously referred. The citation is 2013, 252, CLR 38. And I'm going to read a paragraph from here. This is paragraph 123 of the majority's decision in that case. The relevant principles have their roots in Chapter 3 of the Constitution. As Justice Gummow explained in Farden, the state courts, and the state Supreme Courts in particular, have a constitutionally mandated position in the Australian legal system. Once the notion is rejected, as it must be, that the Constitution permits of different grades or qualities of justice, and it is accepted that the state courts have the constitutional position that has been described, it follows that the parliaments of the states may not legislate to confer powers on state courts which are repugnant to or incompatible with their exercise of the judicial power of the Commonwealth. This is not the whole paragraph, but this is the most emphatic part that I'm relying on. This is 123 in that authority. Now it is a matter of fact that all judicial power in Australia ultimately emanates from the Constitution of the Commonwealth. That would have been so even if we weren't raising any matters that go toward the Constitution. We are raising those matters, but even if we weren't, based on this principle that I've just highlighted, and the common law principle of legality, which has been effectively given constitutional protection in Australia, the second principle is the one that is set out through S32 of the Charter of Human Rights and Responsibilities, and in that respect, I will refer to Coco v. the Queen. So S32 of the Charter effectively states that where the court has to interpret legislation, it has to interpret it in a way that gives a liberal interpretation in respect of the enforcement of rights, and that the court may not presume that any right, if it is arguable that it is affected, would be implicitly abrogated. Where there is ambiguity, it must be settled in favor of the right. And unless the legislature explicitly authorizes the court to limit any right, ambiguity must always be decided in favor of the right being affected. The High Court, especially Chief Justice French, has repeatedly emphasized, in Condon v. Pompano, in Farden, and a number of other authorities, that this principle of legality is an unwritten language, through which the Parliament and the courts communicate with each other. And the Parliament is well aware of this at the time of instituting the laws, or on passing legislation, and the court cannot move away from that interpretation. So what we say is that, based on those two principles, it would be incompatible with the notion that, both in the federal court and in the state court, the same rights are to be enforced to the same extent, that the two notices which, as Your Honor noted, are effectively identical but rely on different aspects of the law, one, the federal legislation, and the other, the state legislation, and the other, the state legislation. It would be repugnant to the notion of the other disparity of justice being dispensed, being consistent across the state and federal courts, that the court interpret the specific provisions of the Charter. So, those are the two preliminary issues that I wanted to address. Now, in relation to how Form 19A, in particular, in our submission, and I speak on behalf of unless I clarify that I'm not speaking on behalf of the three defendants when I address the court, I am speaking on behalf of the three defendants. So in respect of how we say Form 19A prohibits the court from acting further in this matter, the first, and when I address the court in this respect, I'm also addressing the court in respect of, implicitly, how Form 1 prevents the court, because our submission is that both Form 19A and Form 1 are aimed at enforcing the same rights and giving access to the same form of justice. Now we say firstly that it would be contrary to the purpose for which those facilities exist, that the court have the power to prevent access to them. Those measures exist because judges in the Supreme Courts and in the federal courts have tremendous power, which they exercise to dispense justice, not because they have a constitutionally enforced higher position than the rest of the citizens, But at the same time there must be checks and balances in a democracy, and those two provisions are the manner through which the legislature has empowered the public to have some checks and balances, where they are of the view that a judge is abusing power. It would be absurd if the judge who was alleged to be abusing power could himself prevent checks and balances in respect of that abuse. And it would certainly be capable of giving rise to the apprehension that, or undermining public confidence in the judiciary. I had previously cited, and I will cite again, I request Your Honour to take judicial notice of the fact that 3AB Radio last week cited a report which stated that public confidence in the judiciary in Victoria is currently at 30%, which is historic low levels. We say that this matter, and its publicisation, which is ongoing and imminent, will further undermine public confidence in the judiciary, and I cite just looking for the authority, DPP v. Smith. The citation is 1991, 1 VR 63. It sets out the considerations that the court must bear in mind when a matter is of some public notoriety, and there are allegations made against government agencies, and that it is not actually the legitimacy of the allegations, but the fact of their existence that undermines public confidence in the administration of justice, and the court must then err on the side of caution and afford every means possible to prevent those accusations from festering. I note that the YouTube videos that we have posted have received, and this is a matter of, again, public record. One can go to the YouTube profile, and it will show what I'm saying. But they have received, I'm just confirming what the amount is, as of this moment. These are the videos of the VLSB breaking into the office and acting improperly, and the police colluding with them, and related matters. So they have received around 270,000 views. In DPP v. Smith, the matter had been made familiar to around 500 people. We have cited the analytics report from YouTube that we've generated, which shows how many of those roughly 300,000 people are from Victoria, and it is the predominant majority are from New South Wales and Victoria. A very large proportion of that predominant majority are from Victoria, those viewers. So it's safe to say, over 100,000 people from Victoria are familiar with the matter, and there's impending publications and broadcasts in this matter that are due. So we say that it is the nature of the allegations that are being made, which means that the court, in the interests of the public perception and maintenance of public confidence and justice, the court should not interfere in our ability to enforce checks and balances in this matter. And in any event, the court is obliged and has no power to proceed without determining that those applications that we have made against Your Honour, alleging the commission of criminal offences, and the notices that have been filed pursuant to those, have been done exclusively for the purpose of obstructing the administration of justice, which is a criminal offence, both under the IBAC Act, the PIDA, and it also would be contempt of court, by scandalizing the affairs of the court, possibly, sub judice. So what we're saying here is that, specifically in circumstances where we're inviting the court to either find that we are committing criminal offences, or afford us our due process, in those circumstances, it would be absolutely destructively harmful to the public maintenance of public confidence in the administration of justice, if the court continued with this matter, without determining that we were trying to pervert the course of justice. Now, Your Honour mentioned that the timing of the certificate is unfortunate. I mean, I do not understand why it's unfortunate, because it had been foreshadowed. It's not like it was first conceived of at whatever time it was filed. It had been repeatedly foreshadowed. It was foreshadowed a few months ago. Then, on Thursday, Mr. Ansell swore an affidavit in which he said that we would have done all of these things had I not gotten ill. I said that as far as I remember during the hearing. We haven't received the transcript yet, but I cannot see how the court asked us quite improperly how we could not have anticipated that the LSB would rely on specific sections of the uniform law, because there are only so many sections they could have relied on, so we should have anticipated everything, and prepared in that respect, prepared in that way. We say that the court should apply a similar way of thinking in this matter. And, where we have specifically identified that the forms would have been lodged if I were not ill, and would inevitably be lodged. In fact, I've given undertakings in this court in respect of the fact that I will use every process I can to hold everyone accountable who I suspect to have done it. Something improper in relation to these matters. I missed my grandmother's funeral because of these things. And this matter is more than an administrative or a commercial issue to me. So the simple fact is that besides the fact that there's a statutory prohibition in this matter, we say that the Constitution is invoked, because all judicial power comes from the Constitution of the Commonwealth. This has been clarified in a number of authorities which I have previously cited. Kirk is another one. Kirk v. Industrial Commission of New South Wales. Your Honour has previously stated that Your Honour is familiar with that matter. What that authority clarifies is that the state parliament is incapable of fundamentally changing the character of a state Supreme Court by the Constitution, through the Constitution of the state, because there are certain intrinsic aspects of a Supreme Court which are underpinned by the judicial authority that comes from the Constitution, and those aspects cannot be curtailed. In fact, Cable is, again, one of the most prominent authorities in support of that argument. The citation is Cable v. Director of Public Prosecutions, New South Wales, 1996, 189, CLR 51. And then the second Cable authority also reinforces the same point, New South Wales v. Cable, 2013, 252, CLR 118. So, even if the Parliament wanted to, they could not change the fundamental character of the Supreme Court, because the judicial authority derives from the Supreme Court. Now, what aspects of the federal, or of the Constitution are invoked? We say that the right to legal representation, and the right of a lawyer to access the court, are matters that are constitutionally protected, and they are protected constitutionally through the manner in which Chapter 3 is interpreted, and they are also protected under the Judiciary Act. I can take Your Honour to the sections of the Judiciary Act in that respect. So, S78 of the Judiciary Act gives an unequivocal right for parties to be represented by lawyers. Implicit to the enforcement of that right is the principle that if a lawyer is being improperly prevented from representing a party, it is a constitutional infringement of that party's right. Then, and I'm going to cite an authority for this interpretation of the document, of the legislation, then I also rely on S55A and S55B of the Judiciary Act. They set out the right, the statutory right, and the constitutional right of lawyers to address the court.
What was that?
Sections 55A and B. So, 55A and 55B, they're not subsections but separate sections of the Judiciary Act. They set out that lawyers have a right to practice in or address federal courts. Now I'm going to cite this authority. And often when I cite authorities, Your Honour does not address the principles in there and simply says that mostly Your Honour doesn't even mention the authorities, but when you do, you miss the principles completely. I would like you to address the principles in the judgment. I say this for emphasis. The authority is MN Legal and Management Consultants Pty Limited versus the, sorry, this is not the version of the authority that I'm looking at. I will provide the court with a citation for the authority imminently. Okay, yes, it is actually that. It's MN Legal and Management Consultants Pty Limited versus the Council of the Law Society of New South Wales. Just 1 minute here, Your Honour. Sorry, I found the right one. It's APLA Limited. So that MN Legal was not the one I was relying on. It's actually APLA Limited, v. Legal Services Commissioner of New South Wales, 2005, HCA 44.
Sorry, 2005?
HCA.
Yes.
44.
44?
Yes. So in that case, what had happened is the Legal Commissioner of New South Wales had passed a regulation or caused some legislation to be affected. A regulation to be affected, which limited or prevented the manner in which some lawyers could advertise in classifieds for personal injury-related, for the provision of personal injury-related services. This was done purportedly to prevent the public confidence in the legal profession from being undermined because of undignified or aggressive advertisement practices by some lawyers. What the High Court determined was that the Legal Services Commissioner did not have the power to frustrate or limit in any manner any aspects of the dispensation of legal services which could theoretically prevent access to courts. In this case, we say that the whole point of taking away Mr. Ansell's license was to prevent him from being able to represent the company, and us, in respect of important matters, and to be able to brief barristers.
You say that, but Mr. Ansell, every time he gets the...
I was just addressing that. I know what...
Every time he gets the opportunity he says, I can't talk. I want Mr. Kuksal to talk.
But here he is not an advocate. But he could file subpoenas.
All right.
And you couldn't have stopped us then.
So the point of taking away the license was to?
Impede him.
Prevent him acting as a lawyer.
As a lawyer. Because he can't brief barristers as well now.
Yes. Okay. I understand your point.
And we could have filed documents which we have to now come through you. We have to pick up they're fighting him on affirming affidavits.
Yes.
He can't hire lawyers to work under him, he has physical disabilities.
It's 20 past almost, Mr. Kuksal.
Your Honor, I'm not abusing the court's time. Now the point of that, the intervention in Mr. Ansell's ability to practice, which is unlawful, and is being maintained through improper threats, has only been effected after he had commenced the proceedings against the Legal Services Board. It did not happen before that, and the Legal Services Board has clarified on affidavit, which we have exhibited in this proceeding. They've clarified that in a VCAT proceeding. We've exhibited that to this, in this proceeding. It's the affidavit of Ms. D. Gregorio from the 21st of December 22, which was exhibited to Mr. Ansell's affidavit of the 1st of August. The affidavit is by Ms. Iacono, of VLSB, and it clarifies that the only reason why the LSB is preventing Mr. Ansell from practicing is because of their suspicion, which they were investigating at the time. This was in 2022, that he may have been involved in he may have enabled me to engage in unqualified legal practice. That was the sole reason why they were preventing him. Or there was another reason mentioned, which could not have been lawfully applicable, which was that he was possible contributing to the breach of overarching obligations of the Civil Procedure Act, which the LSB is not entitled to enforce, especially through the mechanism of intervening in licenses. So this is on affidavit by an officer of the Legal Services Board, that the sole reason is because he may be permitting me to effectively engage in unqualified legal practice. In the sense that I have corporations, and in the proceedings in which the firm represented those corporations, if I contributed to the preparation of documents, then I wasn't technically representing myself. It's an absurd line of reasoning, because as a client, or as the instructor on behalf of the client, I have every right to instruct the lawyers. And I have never shied away from identifying my involvement in proceedings. So there was no basis, and I note that no charges were even pursued or considered, and the statute of limitations has now expired. So that investigation led to nothing, and since it was the sole purpose, there could be no basis, which is why they relied on Your Honor's impropriety to slip in criminal allegations without due process. Because the proper procedure to stop someone is not by refusing to renew their license, but to having them struck off the roll of the lawyers in the Supreme Court. If they're really interested in the public interest, they need to make an application to have Mr. Ansell struck off the roll. Because until then he will continue to have statutory rights, and another, they transparently nefarious tactic in all of this, is that they're relying on a criminal provision, without clarifying anything about mens rea, or anything about due process. It is not enough for Mr. Ansell to be an ostensible technical breach of a section, to have contravened that section of the legal sense. If that section relates to a criminal offense, there is an implicit aspect of an intention to knowingly commit an offense that has to be read into that section. And that is clear from the Constitution Chapter 3 but has been further emphatically pronounced in Hecate versus the Queen. So, HE space KAW space TEH versus the Queen, 1985, HCA 43. They have also not clarified that at any point in time, they told him to stop doing what he's alleged to have been doing. There's no affidavit material that says that Mr. Ansell was asked not to do something, and then he knew that he was doing it, and he was doing it contrary to the law and he continued to do it. Nothing purports to that, and we're going to rely on Matsukatidu versus Yarra Rangers Council, 2017, VSC 61. That's MATSOUKATIDOU versus Yarra Rangers Council. The citation is 2017 VSC 61, and Tomasevich versus Travaglini. Citation is 2007, VSC 337, both are judgments of the celebrated Justice Bell. In those authorities, His Honour has clarified that the whole point of the human rights legislation, and the ICCPR, which is the federal equivalent, or which has been enforced through the Australian Human Rights Commission, as the equivalent to the Charter of Human Rights and Responsibilities in Victoria. They all clarify that is it the substance of the right and not its technical form, that the court has to give a debt to. And what His Honour has clarified in those matters, is that when the court has to consider the impact on due process in criminal proceedings and so on, the court has to consider the substance of the rights and not their form. So these proceedings are criminal in character. There is also clear from Cable. In Cable the Parliament have passed legislation to obstruct or impede, or litigate the operation of organised crime by having some associations declared criminal networks or gangs, through a process that did not afford people who would ultimately be affected by that determination due process. So the legislation authorized the Chief Commissioner to apply to a judge, a designated judge of the Supreme Court, to have an organization declared a criminal enterprise. and then after that, once that was so, any person having financial transactions with that enterprise could have their assets seized and criminal action taken against them, but they would then be afforded due process. The High Court struck down that law because it predetermined, or it largely limited the court in respect of issues that would ultimately be relevant to criminal proceedings. The court has no power to do that. In these matters, what is being asked is for the court to determine that Mr. Ansell has committed a criminal offense, although criminal penalties are not being sought. But that is no different, by the way, from, for instance, the proper criminal, or conventional, I should say, criminal proceeding, being commenced in accordance with the Criminal Procedure Act, and the prosecutor saying that they're not seeking conviction. They're seeking a determination of guilt, but not conviction. It doesn't make the criminal procedure or the human rights that get affected because of it inoperable. It's not the element of conviction that invokes those rights. It's the determination of guilt in respect of an immoral conduct, or of a criminally prohibited act. And that is clear from the reading of Ainsworth v. Criminal Justice Commission, 1992, HCA 10. It has substantial reputation aspects, implications for Mr. Ansell, for us. It has tertiary property implications, his right to earn a livelihood, and the other aspect of it is, I'm going to cite this authority. It's This was an application brought by Belhage on behalf of the Sovereign versus Direct, Belhage, BELHAJVDPP, and another, number 1. The citation is 2018 UK South Carolina 33. It was unequivocally emphasized in that authority what I have just said about criminal rights, about rights in relation to criminal matters. In any proceeding, so long as an aspect of a criminal allegation gets involved, anybody who is foreseeably affected, and not directly, but foreseeably affected by that determination, has a right to be heard by the court, and to have their rights enforced in accordance with the human rights that apply to criminal proceedings. Justice Janane has emphasized as much in proceedings that we were bringing against certain police officers in the state, where even though we were not seeking criminal sanctions, and they were effectively in the form of declarations that would feed tort law claims and also disciplinary actions, that those parties would be ultimately eligible to be heard properly, and they were to be joined, and that process is underway. So in effect, and it's an uncontroversial principle of law, which has been repeatedly affirmed by all authorities of the High Court and the Supreme Court in the UK, that where there is an aspect of human right that is being affected, it is not the form, but the substance, that matters. And S32 of the Charter of Rights also clarifies that. I also note that there are a number of provisions within the Charter of Human Rights and Responsibilities, which clarify that firstly, no law is to be passed without a statement of compatibility being prepared by the Parliament, or some representative of the Parliament, which clarifies that that particular act or certain provisions of that act render the enforceability of the Charter of Human Rights and Responsibilities inoperable. This is not the case in respect of the provisions that the LSBC is relying on. The Parliament has not clarified that those particular provisions render the rights in relation to criminal process unenforceable. For instance, there are certain provisions of the ASIC Act by comparison that clarify that for regulatory purposes the Parliament is permitting the abrogation of, for instance, the right against self-incrimination. Those particular provisions of the Uniform Law have nothing to say about that. In those circumstances, what we say is that if the court is making a mistake, it is making a horrible mistake, especially in circumstances where we're directly that the court is doing it in bad faith, and in circumstances where I have undertaken to sue the court, and we say that this is a detrimental action in response to that. So in those circumstances, the Attorney General should be given an opportunity, and we should be given an opportunity, to require the Attorneys General to protect our rights, as the first law officer of the state, where the court is failing us repeatedly and brazenly, and other Attorney General must be given an opportunity under the Constitution to clarify their views on the subject. We know that we've served the notices on the Attorney General of Victoria, and we've served the notices on the Human Rights Commission, the Equal Opportunity and Human Rights Commission of Victoria. We are in the process of serving the other Attorneys General. It will happen today, and I'm told that we have served the other Attorneys General as well. So the Victorian one has been served. The others we're in the process of serving. The court does not have the right to prevent them from having a say, because whatever the court rules today, if it does go on improperly to rule, it has an impact on the law in other states as well, or its interpretation. Your Honour cannot deny the principle of comity, and its strict implementation, and it has the potential of perverting the course of justice, not just in this proceeding, or in these proceedings, but also in a number of other proceedings, for us and the other residents of this country. We also say that once any allegation is made, that is in respect of the violation of a constitutional right, S39 of the Judiciary Act, effectively invokes the federal jurisdiction in the Supreme Court of the state. So we say S39 is the operable part of the Judiciary Act, which invokes the legislation of the federal jurisdiction. I'm also going to cite quickly these authorities, which further clarify how the federal jurisdiction is invoked. These are, I have previously referred to them repeatedly as well, and, so in Sloan versus Sloan, spelled as Sloane, I've cited this very authority to Your Honor before, versus Minister for Immigration, Local Government, and Ethnic Affairs, 1992, FCA 414. The full court of the Federal Court of Australia ruled that, this is paragraph 26, as a starting point for consideration of the Act, it should be noted that, now this is at paragraph B, an exercise of federal jurisdiction may be attracted not only by the assertion of a plaintiff seeking relief, but by a pleading by way of defense, and may be attracted for the first time in the course of conduct of an appeal. Once federal jurisdiction is attracted in a proceeding in a state court, the jurisdiction which is exercised by that court throughout the case will be federal, and there will remain no state jurisdiction capable of concurrent exercise with the federal jurisdiction. Now, they had said that the exception is, if there was a completely disparate aspect of the proceeding, which is then separated, and then they've cited, the full court cited Felton v. Mulligan, 1971. This is a High Court authority, 124 CLR, 367, at 373, in support of that proposition. And in subparagraph D of that proceeding, they referred to S39(2) of the ITS 39(2) of the Judiciary Act as capable of giving rise to that jurisdiction. So, we say that, besides the things that I've said, there is another fundamental aspect of the federal jurisdiction, which applies here. Under the Constitution, and I'm citing the following authorities in support of this proposition.
Your Honor, can I just rise, just to note the time? It's currently 12:45.
Yes.
12:40 p.m.
The technicalities, Your Honor.
Yes,
That's what they're
thanks.
focused on.
No, Mr. Kuksal.
Your Honor, there's a High Court authority that says that it's dishonorable conduct for a body to take technical points.
Mr. Kuksal, please, don't raise your voice at me.
I'm not raising your voice at Your Honor.
Well,
I'm just infuriated by
perhaps
Mr. McAuliffe's presence.
All right, Mr. Kuksal, you're not entitled to be infuriated
I am entitled
by someone's presence at the bar table. I said you had to stop at 11.30 to 12.30. I've given you another. I will give you till 1 o'clock.
It's not 12.45, by the way. It's 12.41. He also lied.
No, I think he said, the 45 minutes is up. I'll give you till 1 o'clock, okay? I'll give you till lunchtime, and then I'm going to reflect on it over lunchtime. But anything you want to say to me has got to be said by 1 o'clock.
I am trying my best, Your Honor, acting in good faith, and I'm trying to do my best, which would be clear from the transcript. I rely on the following authorities. Nicholas v. R., 1998, HCA 9, Chu Keng Lim v. Minister for Immigration, 1992, 176, CLR 1, Assistant Commissioner Michael. Well, this is Condon v. Pompano.
I can't write these down as quickly as you're reading them.
I can send a document with.
No, because I'm going to.
During lunch before.
Look at this over lunch. No, you're not going to send.
Within 5 minutes of lunchtime, I can send. Nicholas v. R., 1998, HCA 9, City of Enfield Development Assessment Commission, City of Enfield v. Development Assessment Commission, 2000, 199 CLR 135.
So 2000.
2000, just 2000.
Yes?
199 CLR 135. RV2E, T, OOHEY. Ex parte, Northern Land Council, 1981, CLR 170. Now, in the Toohey proceeding in particular, what the court had said was that it was, I'm paraphrasing but there were some very strong words used, but an exercise in folly, to say that the operation of law enforcement or public agencies will be impeded if everybody was allowed to raise allegations of corruption or improper purpose. The court has no power not to determine those, and what the court clarified was that everybody is equal under the law, and that in the long run it is actually more efficient, because public agencies then know that they will be held to account. And it doesn't end anything, it just leads to more litigation. Now, S64 of the Judiciary Act also clarifies that the court has no power to presume the regularity of any conduct by the LSB. I say, S32 of the Charter also gives the same effect. Section 25 of the Crown Proceedings Act, in particular, this is a state legislation, mirrors S64 of the Judiciary Act. And I note here that part of my fury, which I am controlling, is because of the things that Mr. McAuliffe has said in this and related proceedings, including the fact that Mr. Rapke had the right to waive my privilege when he basically allowed Mr. Kuchiyara to record the content of the case files that the firm was maintaining in the proceedings that it was conducting against Mr. Kuchiyara. He said that Mr. Rapke waived my privilege, lawfully, and that I need to give evidence to prove that that wasn't the case. He lied to Justice Janane directly, and said that a person identified as Anna was not Anna Alavazopoulos, of the Legal Services Board.
Do I need to hear?
But possibly a different Anna. No, Your Honor.
Do I need to hear this in the 15 minutes?
Yes, because I have said something, and it was contrary to my interests, that I don't clarify why I'm furious with him. And on Thursday, he said that Ms. Shaw may have otherwise had a legitimate reason to have an adjournment, but because that reason falls in support of an application in conjunction with perhaps less honorable reasons, that undermines the potency of that reason to get an adjournment. He was inciting Your Honor to break the law. It's contrary to what he's supposed to do. And, as per the law, he stops being a lawyer when he stops acting like one. This is Weaver v. Law Council. The citation is, not when the court determines, but from the point when he acts that way. Weaver v. Law Society of New South Wales, 1979, 142, CLR 201. So, Your Honor, we say that the authorities that I've cited, and also in particular, I want to raise Lang. So these are the authorities, being the Enfield Authority, the Toohey Authority, the Nicholas v. the Queen, then Lang, LANGE, v. Australian Broadcasting Corporation, Australian Broadcasting Corporation, Australian Capital Television, Pty Limited versus Commonwealth, No. 2, 1992, 108, ALR 577.
1992?
108 ALR 577. Miller v. TCN, Channel 9 Pty Limited, 1986, 161, CLR.
So that's 1986.
161.
Yes?
CLR.
Yes?
556. Lynch v. Brisbane City Council, 1961, 104 CLR 353. All of these authorities clarify an important aspect.
So what's the principle they establish?
Yes, that's what I'm getting at, Your Honor. The principle that they stand for is the principle of representative and responsible governance being necessary for the operation of the law. What the High Court has clarified in these authorities is that the operation of Chapter 3 of the Constitution, which is basically the source of the judicial power in this country, not only enforces, but presumes the operation of the rule of law. If there was no rule of law, the court could not function. Administratively, logistically, in every way it could not function. If the Parliament passed laws that were fundamentally atrocious and oppressive, the court could not maintain its legitimacy in enforcing those laws. That's what the authorities clarify. So similarly, if the executive was acting in a way that was incompatible with the responsible and representative form of governance, then the court does not have a choice, but an obligation to remedy that. This was also emphatically stated in City of Adelaide, Attorney Generals of South Australia v. Corporation of the City of Adelaide, 2013, 249, CLR 1. So it's the principle of proportionality, Your Honor, which works in conjunction with the principle of legality. The principle of legality says that the law has to be interpreted in a way that, except for explicit abrogation and implied curtailment of rights, cannot be read into the law. And the express abrogation has to be exhaustively described in relation to its operation for clarification, especially when it comes to the legal operation of legal profession or legal privilege, because it is a substantial right. It's one of the few constitutionally protected rights in Australia. In Commonwealth countries, Baker v. Campbell clarifies this, 1983, 153, CLR 52. So, that's the principle of legality. Now the principle of proportionality, which is what the recent authority that I cited stands for, says that even in instances where the Parliament can abrogate lawfully some constitutionally protected rights, and even in cases where that abrogation has been that abrogation which is sanctioned by the law is to be effected by the administrative bodies, the whole operation is lawful only to the extent that the higher right that was to be enforced, the higher right of public interest that was to be enforced through the abrogation of a specific person's right. So, the right of the community or the interests of the community, that was to be priorities over the person's interest. It was necessary, and inevitable, that the person's interest be abrogated to protect that right of the community, in that specific way. And in a very particular sense, not a theoretical sense, but there has to be a direct link, that there was no other way of preventing harm to the community, in that particular instance. Not the notion of it. And that the abrogation was limited to the extent of that particular prevention of harm, and did not extend to related matters. If the authority to abrogate laws is otherwise abused by the Parliament or the administrative body, then that's a breach of the constitutional requirement for proportionality in the governance of the state, and then the court has no choice. Now, what this court is in fact doing, is that it is refusing to hear us about whether or not proportionality has been violated, which is in itself perverse. So, this court has lost its legitimacy, in our submission, to function as a court of law, when it basically, and I note that in his opposition, that Your Honour was dishonest about reneging on the explicit commitment that Justice Forbes had made to us, and we say the implicit, and part of the explicit commitment that Your Honour had made to us in February, that the legitimacy of these proceedings will be determined before their conclusion. Justice Forbes had clearly said that she was not making any finding of issue. She had not even admitted their affidavits at that point, on my objection that the legitimacy of the proceeding had to be determined, and she had accepted that she would do it. And the injunction was not made, by the way, it was made in a gross error of law, and she recused herself when I sued her about that. But the fact is that even to the extent that she made the order, it was not made in a vacuum. It was made with the explicit assurance to us that the court would determine the legitimacy of these proceedings. When I raised this with Your Honour in February, it was clear to us that Your Honour accepted that, and said words that clearly indicated that. For the first time on Thursday, Your Honour sought to move away from that very irrevocable commitment to us, and on Friday Your Honour lied in my submission, and I think everybody agrees that, I know that everybody agrees that Your Honour was dishonest about I say defendants when I say everybody, that Your Honour had not made those representations and Your Honour did not actually identify anything contrary to what I had said from the transcript, or refer to any part of the transcript to say that this is what was said instead, or Mr. Kuksal or the defendants are misinterpreting it. The provision of inadequate reasons is an error of law. It can be a jurisdictional error in certain circumstances. We say that that is the case. I also note that we have made a recusal application, which Your Honour did not decide. It was raised through Mr. Ansell's affidavit, and I said that this court did not have legitimacy. That is we do not need to explicitly say the word recusal. When we raise allegations of denial of procedural fairness, the court loses jurisdiction until it decides that there is none. Those aspects were not addressed in Your Honour's judgment. The whole matter is being carried on in a completely haphazard way that scandalizes the affairs of the court, and I cannot see how, in effect, the matters could be conducted in a more corrupt way by the court. In the Your Honour, you've seen the videos, and then you've suggested to them that they make an application that it's irrelevant that the court decide that Mr. Rapke breached the uniform. He committed criminal conduct, and you've suggested to them that they raise the issue that it's highly irrelevant. You suggested to them on Thursday that they single out Mr. Ansell.
Why is that a submission in support of your adjournment application?
I'm saying you're acting corruptly. The Attorney General should.
I know you say I'm acting.
The Attorney General should. I'm saying that it would be, first of all, you do not have the power to stop us from relying on our right to have the Attorney General protect us from you. When that happens, and even in a circumstance where maybe we're wrong, and the court could decide you should not decide it, given what is being alleged against you and given that you have not determined that it is being alleged for the sake of improperly stopping you from deciding the matter, you should come out and decide that. You should hear us and decide that if that is the case.
How would I do that? Have a trial on that issue?
You can do it two ways. If you are reasonably confident that that is the case.
No, I'm just exploring what you mean.
Yeah, I'm telling you what the two options are from my understanding. One is you refer the matter to the Prother Notary to file a charge sheet for contempt.
So the case stops for 6 months or however long it takes to determine that.
That's the due process.
All right.
Okay? So, Your Honour, we would be committing a criminal.
So your argument is, a party can come along and make very serious allegations as a judge.
Absolutely.
And by doing so, cause the proceeding to cease for 6 months or so whilst there's
if they're willing to commit a criminal offence?
Whilst there's an investigation into that, whether that's been unlawfully improperly made or not.
Your Honour.
So effectively, pariah.
Let me just answer that question. I have a very good response to that question.
Yes.
So if someone really wanted to stop a judge from hearing the matter, they could just assault a judge. The judge would have to stop from themselves. The judge could not hear the matter any further. The person would commit a criminal offense.
Depends, maybe.
No, it's 100% thing. If someone threw a water bottle at a judge, even if it didn't hit them, there would the judge would have to stop in the matter. This is the system of law that we're in. What we're doing is a more serious criminal offense than a minor assault. Under the IBAC Act, making the allegation that we've made against you is a more serious criminal offense. The criminal penalty in terms of imprisonment.
You're saying just because you started off talking about inquiring about whether people were acting properly, are you saying that you making the complaint to IBAC is potentially a very serious criminal offense?
Absolutely.
If it's made for an improper purpose.
Absolutely. That's the protection I'm seeing. When Your Honor has to consider this fact, what Your Honor has to consider is that the risk we are taking to stop Your Honor from hearing the matter is much greater than the risk that one would have to take in throwing a water bottle next to a judge, which would achieve the same effect.
Yes.
Judges do not have a right to stay in proceedings. They have a duty to stay in them.
He says.
For the maintenance of public confidence. We say in this case, Your Honor, the matters that are raised in the notices you have to come out and decide them against us. The individual items on the notices, that you didn't rely on ex-parte communication to decide a matter, that you did, that you have to hear our evidence about it. That's the second way you can do it, except for the profanatory. You can come out, you can hear our evidence, then you can decide, give a judgment, about how those specific matters that we've raised in the notices.
I thought you said I couldn't sit in judgment on that, because I'd be sitting on judgment on something that involved myself.
I'm saying it would be improper.
I thought you said that this was one of two alternatives that were open.
Yes, but I'm saying the other alternative is better.
One of the two alternatives you say is open is in fact an improper alternative.
Well, it's an alternative that is exercised in the case of necessity. Yes, okay. So that it's not unlawful, it's an extreme measure.
Less desirable.
Less desirable, that's right. It's an extreme measure that can be exercised in cases where there's a necessity requirement, because for instance the allegations are such that there's a terrorism threat or whatever and needs to be done right now, or there is no more judges available.
Right.
But we say that you have to decide those issues, without which it will scandalize the affairs of the court.
Yes, thanks Mr. Kuksal.
Thank you.
We'll adjourn now until 2.15. Ms. Shu, Mr. Kuksal. Mr. Kuksal has told me he was addressing his admissions on behalf of all defendants.
Not exhaustively.
Maybe once we'll just make an additional...
How long are you going to be?
10, 15 minutes.
No.
Your Honor, I wasn't speaking exhaustively. I never...
You've got 5. Tell me what you're going to say then, Ms. Shu.
So in terms of S35 notice?
Yes.
So I think 10 minutes would be...
Just start talking. Tell me what it is you want to say.
Can I?
Yes, please sit there.
Okay, so the relevant provision for filing the notice is, that's a party to a proceeding must give notice to in the prescribed form. That's what we do to the Attorney General and the Commission, in the case of a Supreme Court proceeding or a county court proceeding, and the question of law arises that relates to an application of this charter. Or a question arises with respect to the interpretation of a statutory provision in accordance with this charter. So what I want to raise is that we say that under the charter we have the rights against self-incrimination, and by the LSB's filing of the notice to omit I think 2 weeks ago, I can't remember the exact date. So, they filed a notice to omit under the civil procedures, and that would be violating our charter rights based on that. That would be yes a violation against our rights or rights under the charter farce.
Mr. Kuksal, I'm listening to Ms. Shu. It's just unhelpful for you to be speaking over the top of her.
And I say that's one of the reasons that it was raised a bit later was because that notice was not filed until not very long ago. So we want to raise this question about this violation, and obviously have those issues also notified to the Attorney General and Human Rights Commission about this issue. So I have previously raised to the court that I have some concerns about the deponents of LSB's affidavits. So I'm concerned that I will not be able to cross-examine the members from the Legal Services Board in relation to their actions taken against me and others. So my concern is that they, in filing the notice to admit under a civil procedure, then they will be arguing that you are admitting those facts and that's why we're not going to present our witness for you to cross-examine. And that's again will violate S25K, so small k, of the Charter. So that says that, so one is not to be compelled to testify against himself or herself, or to confess guilt, And this really is, it's conflicting operation of the notice to admit.
Right. So you say that this notice to admit was in breach of 27 to 25, K.
Yes, for they don't operate.
Under the Constitution.
No.
So, and the other fact that I want to raise is in the constitutional rights. I want to add that. And the other fact is that I want to read the very small part of Your Honor's judgment on last Friday.
Yes.
So that's the last paragraph. So paragraph 39. Your Honor said that Mr. Ansell should know what he has done and why, and be able to present argument on whether it was a breach of S10 of the Uniform Law. So this is in support of Mr. Kuksal's application about them using the civil proceeding to prosecute a criminal case. And again, I want to raise this in and make sure it's in the transcript, that S10 and section.
This is an application for an adjournment I'm to do.
Yes.
So tell me what that's got to do with the application referred to.
So Your Honor's decision last Friday had shown or had made me believe that this is no longer a civil proceeding, that they're asking for an injunction by saying that Mr. Ansell needs to present an argument on whether it was a breach of S10 of the Uniform Law. Your Honor had this intention.
Ms. Shu.
Yes.
No, you go on.
Your Honor had shown your intention in cross, helping Legal Services Board unlawfully prosecuting us in the criminal, with allegations.
Because I said that Mr. Ansell will be an extra witness to be expected to be in a position to address the court today on the claim against him, I have done what wrong?
You have shown an intention to
help the board?
Help the board. I would say unlawfully or in an abusive process.
Okay.
In abusive court's process, in litigating or prosecuting a criminal offense.
Okay.
And previously it was always understood that it was only an injunction application.
All right. It is only an injunction application as I see it.
Sorry,
Your Honor, issues of...
Mr. Kuksal, I've had enough. Heard enough from you.
Issues of...
And, can I just quote a very short paragraph? Sorry? It's actually from our proceedings. That's Kuksal versus State of Victoria, 2023, VSC 625. So, this is paragraph 246. In that case, Justice Janine had basically dismissed our application to forejoinder, and he said that this court would be asked to make findings about the plaintiff's allegations of criminal conduct by persons, without those persons receiving the rights and the protections afforded by a criminal trial. So it was the court's position that you can't make findings, or you shouldn't be making findings, of criminal character without the protection afforded by a criminal trial.
Standard.
All right. Thanks very much.
Your Honor, the applications were not dismissed.
Adjourn the court till we'll resume the court. Had you finished, Miss Shu? I got the impression you had finished.
No, it wasn't.
No, Mr. Kuksal. Mr. Kuksal.
Dismissed.
You've had...
Your Honor, she said something wrong, which affects... It wasn't dismissed. It was stayed. Until the determination.
All right.
Of the proceeding in the magistrates.
Yes. Yes, go ahead.
I do have one last point to make. That is for calling the court to clarify the interpretation of S6 of the Application Act. So,
Section 6 of
Uniform Law.
The Uniform Application Act, where it says that...
Well, what has this got to do with an adjournment application?
Because this is related to the notice filed under the S35 of the Human Rights.
All right.
Charter of Human Rights. So basically S6 of the Uniform Law Application Act says that the Charter of Human Rights and Responsibilities Act has no application to Schedule 1 of this Act. And I asked the court to clarify how it is applicable to our proceeding, and then why, in terms of how it has no application, does it apply to the civil proceeding in the Supreme Court, and also the criminal proceeding that's related to their actions taken.
All right, thanks. Mr. Kavanaugh, I assume from your silence that your client was opposing the application, but I should have had you articulate whether that was the case or not.
That's so, Your Honor, and I think Your Honor might have elevated me to a position I should not have had, calling me Mr. Kavanaugh there. But...
I'm sorry.
McAuliffe, Your Honor.
Mr. McAuliffe, sorry.
No.
I don't need to hear from you. I'm going to dismiss the application for an adjournment, and I will publish reasons promptly. But
If I might just raise a few matters that might assist Your Honor in terms of any reasons, just out of just to make it very clear that there is, first, in relation to the application to adjourn the matter in relation to the Judiciary Act, there's a case that has not been cited which may assist Your Honor, which is ACCC v. Barbados, and that's cited at, it's a case from 1999, 95 FCR 292. And that's a judgment of Justice French, which summarizes and distills principles in relation to whether matters, in relation to notices under the Judiciary Act, and how a court should treat and deal with those. And in particular, Justice French determines at paragraph 14 that for treat, quote, Section 78B does not impose on the court.
I will look at that paragraph.
Yes. In relation to the issue about the charter, that is, in the charter notice I should say, Your Honor, that is a bit more complicated, and I would just wish to be heard slightly on that. There is a judgment that also might assist Your Honor in, which is Vella v. Webecker, from 2015, and that's cited at 303, FLR 315. 303 FLR 315, and that's a decision.
Which year?
2015. That's a decision by Associate Justice Lansdowne, where separate to a 78B notice, there was also a charter notice, and a process was taken up by Her Honor to permit notices to be sent and allow for any submissions, or declining to take up that opportunity, via a timetable that could be set and completed before judgment was delivered in that matter. But certainly, Her Honor determined that the issuing of a notice claiming questions of law under the charter should not delay the trial in that matter.
Yes, thanks.
Yes, thank you, Your Honor.
All right. We will proceed now with your application for the injunction against Mr. Ansell on the basis of what is said to be breach by him of
Excuse me, Your Honor.
S10 of the Uniform Law.
Your Honor, I think that I would be entitled to make my submission in respect of the adjournment. There was a submission for the adjournment in this matter.
Mr. Ansell, you stood up and you said you were making for an adjournment, and then you said you wanted Mr. Kuksal to make it on your behalf.
Your Honor, I was referring to specifically, the reason why I said that was in relation to the applications that had been lodged today. I specifically said that the three of us were co-signatories in relation to that matter.
Yes. So, are you applying for an adjournment for a different reason?
Yes.
All right. What is the reason for which you're applying for an adjournment?
Your Honor, first
of all, have you given anyone any notice of this application?
Not at this stage, Your Honor.
Okay.
With the first issue I wish to raise, Your Honor, is in respect of the fact that Your Honor has made a decision in relation to the application that was put forward this morning by Mr. Kuksal, which was a joint application. I believe that, given the nature of that application, and the circumstances involved, and the fact that there were considerable authorities cited, that we would need to consider your written reasons, and how those written reasons would affect my position. I don't know how they would at this stage, and I think that's a fair and reasonable point.
So you say you don't want to go on until I've provided reasons?
Yes, Your Honor.
I'm against you on that. What's your other application for an adjournment?
Your Honor, in that case the other situation that I would raise is that, again, I think there was a recusal application that had been made on Thursday.
There has not been a recusal application that has been made. An affidavit has been filed.
Correct.
Which has referred to it. No one has applied for a recusal, and no summons has been filed, and no attempt has been made to file one. Are you applying now for an application that I recuse myself?
Yes.
All right. What has happened since the last application on which you rely?
The application that we would rely on, Your Honor, is
your application.
This is my application.
No, sorry.
No, Mr. Kuksal.
But it's...
I'm not going to hear a recusal application other than for Mr. Ansell at the moment.
No, I'm clarifying that this morning, I emphasize that we have made a...
Mr. Kuksal, sit down. I'm listening to Mr. Ansell. You asserted you had made a recusal application. You hadn't made one. You had put in an affidavit at the last minute which talked about one.
I clarified that it was our intention, and our understanding that we had made.
Mr. Kuksal, I'm listening to Mr. Ansell. Sit down.
But it's a collective application in any event. If he's making one right now because...
Mr. Ansell, what has changed since last time?
Your Honor, I'd refer to your, or His Honor, Your Honor's decision in relation to the application this morning.
Okay, yes? Anything else?
No, Your Honor. Again, it's simply a question that we would say that Your Honor has not had the opportunity to consider the authorities that we were cited today. There were numerous authorities in relation to this matter. We believe that, well, certainly, I believe my human rights, certainly, are going to be infringed in relation to proceeding with this matter, being a criminal matter. I would point out, Your Honor, that
You say the fact that I've dismissed the adjournment application is a reason for which I should recuse myself without providing written reasons.
Well, Your Honor, I think what I'm saying is that we can't proceed without written reasons. I don't know.
I'm against you on that, Mr. Kuksal.
Yes, Your Honor, but I can't.
Look, I'm going to say this. I'm not going to hear any oral argument on a recusal application now. I give the parties until 10 o'clock tomorrow morning to put in a written submission in support of a recusal application. I will deal with it on the papers, and I won't make a decision in this matter unless I come back to you and change this order, until I've considered that recusal application. In the circumstances, that's the way I'm going to deal with the recusal application. That applies to both you, Mr. Kuksal, and Ms. Zhu.
Sorry.
Any recusal application is to be made by filing a written submission by 10 o'clock tomorrow morning.
Your Honor, since the decision also affects me and Ms. Zhu.
That's what I'm going to say for you as well, Mr. Kuksal.
Yeah. May I just request some additional time? I think 10 o'clock is...
No.
Your Honor, I don't have the capacity to work on it tonight.
Mr. Kuksal, you can go and do it now for all I care, if you...
But I have other...
Mr. Kuksal, listen, you were talking about, you've told me you have been thinking of a recusal application for some days. You want to address it orally now. You are either in a position to present submissions or you're not. If you're in a position to present submissions, you can put them in writing overnight and give them to me at 10 o'clock tomorrow morning.
Your Honor, I'm entitled to be heard about this.
No, you're not.
You are getting angry about me.
Mr. Kuksal, I'm going to hear...
Requesting to be heard.
I'm letting you be heard about it in writing, by putting something in writing at 10 o'clock tomorrow.
Maybe get until the following day?
No. By 10 o'clock tomorrow morning, you can put something in writing.
So to clarify, not until we couldn't get until Wednesday 10 a.m.?
No. I've said that you have to put in something in writing by 10 o'clock tomorrow morning, and I will consider it on the papers. Mr. McAuliffe, do you want to be heard about that?
Sorry. I have a couple of small matters.
Yes.
In relation to my submission, Your Honor. I have already pointed out that...
Which submission is this?
This is the submission for an adjournment. Your Honor, yes.
The recusal application, or the adjournment?
The adjournment.
Okay, yes?
Your Honor, I have already indicated my physical limitations to argue this matter effectively, and I reiterate those in respect of my ability in regards to being clear on what Your Honor is saying, the questions that are put to me. I believe that I'm disadvantaged if I'm forced to continue on that basis, and that was part of the reasons that we put forward today in relation to the application, the Form 1 and Form 19. Also, I would raise too, Your Honor, in relation to the point that was also raised this morning, in respect of the application that was put to you again on Thursday, in which Mr. Kuksal had talked about S13 and 14 of the Uniform Law. There was a situation there. Mr. Kuksal was quoting the wrong.
Is this... You're applying for an adjournment?
Yes, Your Honor. I'm saying that these are the issues that we would raise with you because I think they weren't considered properly, because, Your Honor, it was Mr. Kuksal's mistake. He misnamed the section.
All right.
Of the Act.
That's no reason for an adjournment.
Well, I'm just saying, Your Honor, he misnamed the section. I think he called the S14 when it was in fact 13.
Yes.
But did actually articulate what S13 was. So, what?
Right.
And that was in support of an adjournment application.
Mr. Kuksal, I'm not listening to you.
Your Honor, so what I'm saying is...
I don't see that as grounds for an adjournment.
No, I think what Mr. Kuksal is saying, that was part of the adjournment application that we were making on.
It doesn't make that. I looked at this. He referred to S14. He meant to refer on S13. I've looked at that over lunch and to me it makes no difference.
So Your Honor looked at S13, looked at the correct section.
I accept that in my written reasons I only referred to the section that Mr. Kuksal had referred to, or identified by number, in his submissions. But when you told me this morning that it was some other section that he had intended to do, I had a look at that section over lunch, and I thought, well, that doesn't... it's not going to change my reasoning.
Right, thank you. Thank you for clarifying that, Your Honor.
But I accept that, if there's an argument down the track that I've made an error.
Yes.
Then we can argue that.
Yes, Your Honor. I understand that you have addressed the correct section. Your Honor, the other issue that I face and the difficulty I face in this matter is, again, this matter has changed fundamentally over the entire course of when it first arose. And it was amended. An amended originating motion was filed in February 24th.
Yes.
The submissions relating to that, which were filed on the 15th of December.
Yes.
Gave no indication whatsoever that they were going to change tack in relation to bringing an application and charges against me, which are criminal charges against me at that time. And in fact, there was no indication that was going to be the case until the submissions of
22nd.
Yes, which I don't think we received until the 22nd of July.
You keep saying that criminal charges are being laid against you. Are there in fact any criminal charges, or is it simply the originating motion and what is submitted?
There are no criminal charges pending. But there's a question of the originating motion.
Okay.
Is raising the issue of finding that there are...
Yes.
That there would be criminal charges.
An allegation. An allegation that you breached a provision of the uniform law.
Yes, but that's... Unqualified legal practice is that type of breach.
All right.
And, Your Honor, the reason why I say this is I think the LSB are being opportunistic in regards to how they've dealt with this matter. Our proceedings in relation to the judicial review proceedings, in regards to the establishment of the jurisdiction of the LSB in this matter, is a matter before you currently. And that was the matter in which, now, we were going to determine the issues of the LSB's jurisdiction.
Yes.
Now, by going the way in which they're attempting to go is to basically breach that matter, because that matter was actually filed before.
Yes, but Mr. Ansell, I have said, and I repeat, that I consider that this application proceeds on the basis that you in fact did not have a practicing certificate, and that it does. This proceeding does not require a determination about whether the failure to renew your practicing certificate was the wrong decision or an unlawful decision. Now, I might be right on that, I might be wrong on that.
Yes, Your Honor.
But that's what I've said, and that's what I'm still, and I'm going to keep saying it. And every time you say to me we can't hear this case because we haven't yet determined whether the Victorian Legal Services Board was acting with an improper purpose when they didn't renew your practicing certificate, I'm going to come back to you and say I disagree.
Your Honor, when you say we, you mean you, is not going to determine the issue in relation to...
I mean...
Yes.
Yes is not going to be determined.
Your Honor, in respect of that, I would say that in this matter originally before Her Honor Justice Forbes, there were comments made that she was going to determine those issues.
Mr. Ansell, yes, but I'm not her, and that's a long time ago.
I understand that, Your Honor, but that puts me in a difficult position because on one hand I've been told, or the indication was that this is how the matter was going to proceed. Now, that's completely changed in the space of a week.
I don't accept that, Mr. Ansell. The originating motion was amended. You've known the relief that they sought, and you've known that the submission is that you were in breach, that you've known as the allegation against you is that you have been engaging in legal practice whilst you did not have a practicing certificate.
Your Honor, in respect of that, I would say that that might have been a general conclusion to draw from the amendment, but it wasn't until 22nd or the 23rd of July that they actually crystallized as to what their argument was. Now, Your Honor, they've had 2 years to bring this application, and then they've decided to do it at the last minute, on the basis that, well, if we get in and run this action, prior to the matter of jurisdiction being heard, then that's a disadvantage to me, and why are they doing it at this time? Have they read any evidence that this is a matter that needs to be determined? Any issues that have to be determined? Is there something that I'm doing wrong that is causing major problems? I don't believe so. Your Honor, I would then move on to, in respect of what they're asking too, is that I actually did say that I hadn't received some documentation in relation to the matter. I was corrected. There was affidavit material that provided material in respect of the matters that they say gave rise to their claims. However, any matter in respect of any claim against me needs to be proved, I think with terminology would be, in respect of, how they came about to make their decision re the matter. Were there complaints made? Was there any material that I should be entitled to? Because these are technically quasi-criminal proceedings that I should receive from the LSB. I've received nothing other than, they've said, oh, this is some of the documents that they're relying on. I don't know.
They've got the documents they're relying on. to try to establish that, in breach of S10, you engaged in legal practice at a time.
Yes, Your Honor.
You didn't have a practicing certificate.
But what I'm saying, Your Honor, is usually any issues in regards to questions under the uniform law, regarding practicing certificates, etc. There needs to be complaints lodged against me.
Why?
I can't point to you the exact section.
Suppose it just comes to the board's intention, other than by a complaint, that somebody without a practicing certificate is engaging in legal practice. Suppose no one is complaining, and suppose all their clients think this person is fantastic, the best lawyer ever, because they come up with all sorts of arguments that they love, and it comes to the board's attention. There's not a complaint, and you say they can't do anything until someone complains.
Your Honor, all I'm asking is that they produce whatever documents they have, and which Your Honor is entitled to under, criminal law.
I don't see that as a proper reason to adjourn the matter, Mr. Ansell.
Well, Your Honor, I am entitled to, I would have thought. In any criminal law proceeding, there is an entitlement that the prosecuting party provide all documentation in respect of the matter.
They're after an injunction. They're not after a fine. They're not trying to penalize you. They're after an injunction.
Well, Your Honor, it's going to penalize me, I think, in other ways, because it's prejudicial to my argument, which I have been running ever since this matter started. The first argument I rose, and this is even before any proceeding started against me or the firm, was that there is a dispute between the parties. Those disputes should be determined before the court, and that was always my situation. Then we had this issue in regards to I advised the LSB on numerous occasions that what was going to happen is that we were going to lodge proceedings to determine a number of issues, which was going to be the jurisdiction. Now, we lodged.
When you say the jurisdiction, you mean the challenge to their purpose in making the decision.
Correct. And I advised the LSB that we had lodged.
Okay, I accept that you have consistently maintained that the VLSB acted wrongly in failing to renew your practicing certificate. I've said that doesn't affect, to my mind, my ability to hear this proceeding.
Your Honor, with all deference.
All right. Well, you disagree with me. Well,
with all deference, I don't believe that's actually the law in regards to the situation.
That's my ruling on it. That's what I've said.
Yes.
I think I've said it twice in writing. I've said it orally. I'm not going to change my mind on it. If the Court of Appeal tells me I'm wrong, then I'm wrong. I'm not interested in hearing further argument to the effect that I should adjourn this matter, because you will say the Victorian Legal Services Board is acting with an improper purpose when it failed to renew your certificate, or in seeking the injunction.
Yes, Your Honor. I suppose that I would extrapolate, a little bit from what I was saying, that this was a jurisdiction issue, but underlying that is what we say was an abusive process in relation to how they've proceeded.
Same thing, isn't it? I mean, either you were engaging in legal practice after October 2022, I think it was, or you weren't.
Yes.
And that's what I'm going to decide.
Well, Your Honor, as I understand it, you've technically already deciding that, because your words were, you don't have a practicing certificate, so it's predetermined.
No, to use your words, I don't know if the words I would use, but I have predetermined in the sense that I've accepted it being common ground, that on October 2022, as from October 2022, according to the board's records, and the situation as has then existed, you did not have a practicing certificate because the board failed to renew yours.
Sorry, Your Honor.
Everybody agrees that in October, if I've got the date right.
Yes, no. In around about October, yes.
I think it's the 22nd of October 22 or thereabouts, the board failed to renew your practicing certificate.
Probably. The terminology would be retrospectively.
Well, whatever the point, as from October 2022, as far as the board's records and the like were concerned, you've not had a practicing certificate. Everyone agrees with that, but you say that they were wrong, that if they'd done the right thing you would have had one. But you didn't.
Correct.
Okay. That's the thing that I have, to use your words, predetermined. And I have only predetermined it in the sense that as I understood it, that is what everybody agrees is the situation, and the real issue in the case has been the issue you want to raise, which is whether they were wrong in a jurisdictional way not to renew your certificate, and also the issue is, have you engaged in legal practice since that time? And it's that latter one which I consider we're here today to determine.
I understand.
And if you have, the next question is, should I make the injunction?
Your Honor, in respect of your comments in regards to that, I'm trying not to repeat myself, Your Honor. So if you could just bear with me for a minute, that'd be good, while I just collect my thoughts. The situation in respect of Your Honor's position is If I can put it this way, there's a provision that exists under the uniform law that basically says that if there is a decision, or if a decision is overturned on appeal or however, then what will happen is that it will be considered that that decision was a nullity from the time it was made.
Yes.
Yes, and that's why I'm saying that that matter should be determined, because, Mr. Ansell, you are repeating yourself. I am repeating.
That's the point that
I'm trying to hammer home a point.
I have said. I understand the argument, and the argument is, until it's been decided about whether the board acted unlawfully, we're in this sort of world where at any time, it might be determined that retrospectively, you did have a practicing certificate. Therefore the matter can't proceed in the meantime. And I've said I disagree.
Your Honor, I am faced with the difficult position at the minute that in regards to the matter continuing, I believe that I do need to seek legal advice, especially now that Your Honor has made determinations of matters which certainly affect my broad rights, and those of my co-defendants. And I would be...
What steps have you taken to get legal advice so far?
Your Honor, we've made some phone calls. The difficulty I had initially in respect of this matter was time, in regards to the 100-old every report tours since to. In regards to record since to once of good.
Mr. Kuksal.
This is, well, Your Honor, I know Your Honor has said that this is.
This is what you said to me yesterday, on the 1st of October, August. I suggested to you that, when we were discussing about these sorts of matters, I suggested, how could you say that you didn't know that their case was that you were engaging in legal practice, without a practicing certificate? And then Mr. Kuksal put in an objection. But then at the start of the next page I said that carried with it, didn't it? An acceptance that if you didn't have a practicing certificate, if you were wrong, and in fact, you didn't have a practicing certificate, then the case could succeed? That is, the case that you were engaging in legal practice. You said yes, Your Honor. That was always the argument. Anim Emphasise gid be playetater by one if dot.
Your Honor, I don't have the advantage of the transcript.
No, that's right.
We haven't received the transcript.
No, Mr. Ansell, I'm against you, I'm afraid. I think you've had plenty of opportunity to get advice on the matter. You are a lawyer.
Yes, Your Honor. As it were pointed out.
I know you say,
this is not my.
You're limited. But you.
This.
You're no fool. You're articulate. You can hear me completely adequately. As far as I can tell, you've had plenty of opportunity to get legal advice. And I think it's appropriate now that I just push on and hear the matter.
Your Honor, the only comment I would make in that regard is that I can, when you say, I can hear clearly, that I do tend to disagree with you in regards to that. You've gotta, if you're sitting on this side, it's not as easy as Darzalikana.
No, Jotad.
You may perceive.
Look, and I'd not meant to trivialize that. If you do have difficulty, and, as I've said, if you have trouble hearing me, let me know. But I have spoken to you a lot in court, and I've never formed the view that you had trouble hearing and communicating with me.
Yes, Your Honor, I Tiristadhs.
Not in a way that has.
I understand your observations, but
cause me concern.
From my side. One final point, Your Honor. Given today's ruling, I believe that we should be given time to consider lodging an appeal against that decision.
All right, well, I'm not going to adjourn it on that basis. If I push on and I end up making the injunction against you, you can appeal and set things aside, and if I've made mistakes along the way, I'm sure you can say that the injunction should be set aside. But I don't see any benefit in delaying this proceeding whilst there's an appeal process has gone through against my ruling denying an adjournment application.
I understand your honest position. However, I would point out that I don't see any prejudice to the LSB in respect of this matter, given that they've bought the matter on 10 days or 12 days ago now.
The thing has been listed.
They could have bought it on a year and a half ago.
But the matter is listed. I've set aside time to hear it.
The time has gone.
We've been making directions for it. The court has to proceed with hearing business. It can't just delay things because somebody might appeal or will appeal or thinks they're going to appeal.
But
or says they're going to appeal, or promises to appeal. The court proceeds on the I proceed, on the basis that what I've done is correct. I think it's correct. And if an appellate court interferes, an appellate court interferes. But until that happens, I push on. You could bury.
Excuse me, Your Honor. Your Honor, final submission is that, would Your Honor consider granting us a stay of 1 week to get an appeal or a decision from the appellate court?
Injunction.
No.
Injunction. I'm sorry.
No. I'm going to proceed to hear the evidence now.
Yes, Your Honor.
Sorry, I thought we had a recusal application that was to be determined, Your Honor.
No. I've said what I've said about that, Mr. Kuksal. You can put something in writing by 10 o'clock tomorrow morning. If I've got something in writing, if I've got a submission supporting a recusal application by 10 o'clock tomorrow morning in writing, I will deal with it either on the papers, or I will ask to be addressed on it. If I don't have a submission in support of that by 10 o'clock tomorrow, I will assume it's not being pursued. But I am not going to delay the further hearing of this matter right now, because of this recusal action you're talking.
But that's incompatible with the law, if you have.
I don't care, Mr. Kuksal. I'm not interested in hearing you say that. I won't make an injunction today. So if you put in a recusal application submission that persuades me tomorrow morning, I will recuse myself, but I won't make an injunction in. I'm not going to delay it in the circumstances until then.
But, Your Honor, that in itself, I'd like to be heard about that, because it may...
Mr. Kuksal, I've heard you enough on it. I've told you what's happening.
No, this is a different matter altogether. You've not heard me about it.
Mr. Kuksal, if you try to disrupt the court, I will have you removed. Now, yes you are. Now listen to me. I have told you, if you want to make a recusal application, you make it in writing, by filing something, by 10 o'clock tomorrow morning.
And I can't make it now?
No, you can't.
So, sorry. I wish to clarify.
Mr. Kuksal, you cannot make it now. I've made a direction in relation to a recusal application. If you want to make a recusal application, you make it in writing by 10 o'clock tomorrow. And I've told you I'm not going to pronounce orders that affect Mr. Ansell or you, in terms of injunctions and the like, before 10 o'clock tomorrow. That's pretty clear.
But we would want to be heard in respect of this application, because there was no...
Mr. Kuksal.
Your Honor, if you could listen to me.
No, I've told you I'm not hearing.
I'm not talking about the adjournment application. I'm talking about a response to their application.
Mr. Kuksal, I would ask you to sit down. I am going to proceed in the application against Mr. Ansell, and if you sit down and keep trying to interrupt, I will have you removed, on the basis that you're disrupting the proceedings.
Are you saying that I don't have a right to be heard in respect of their claims against Mr. Ansell?
At the moment, I'm just going to hear the, yes I am. I'm saying I'm going to hear what Mr. Ansell has to say.
No.
About claims against him.
I'm not talking about that. I'm saying I am a party to this proceeding.
I'm going to listen. Let's just see what's happening first. I want to hear the evidence, and hear what Mr. Ansell has got to say about it. Now what are you saying that you want to just...
I want to address I'm a party in this proceeding. So long as there are matters heard in this proceeding, I have a right to be heard.
Right. No, mister. I am against you on that. I am going to hear what Mr. Ansell has to say insofar as the applications concern him.
If I may open my case, Your Honor?
Yes, Mr. McAuliffe.
Given the limited time that we have available today, it may be best if, rather than opening orally, I would rely on the written submissions, insofar as they are referable to Mr. Ansell. And then, if it assists Your Honor, then we can potentially also provide written submissions in closing, so we can use the time we have available today for the evidence, and complete the application as far as...
And what evidence do you rely on?
Firstly, it's the affidavit of Mr. Matthew Anstey, ANSTEE, that's affirmed the 19th of June 2024. I would seek to read that, or take it as read.
Yes.
In relation to those matters, and of course all of these two witnesses which I will rely upon are available for cross-examination.
What has happened to the notice to admit?
Well, that was the next thing to come to. The notice to admit certainly has been filed and served. There has been no response provided against that, and no denials.
When was that served?
The 15th of July. I will just turn that up.
It's dated the 15th of June.
It is indeed, but it's, as I understand it, just pardon me a moment, Your Honor. It is dated the 15th of June, but it was not filed on Redcrest until the 15th of July.
So you say it was served when? When was that served?
The 15th of July.
So do you say, has the time run out?
Yes. That was on the 30th of July.
All right. You proved it was served? Mr. Ansell, do you require them to prove that it was served on you? Or do you accept that you were served with it on or about the 15th of July?
Your Honor, we accept that it was served. You're talking, the notice to admit.
Yes, and?
Yes, we accept that it's served. The issue we have with it is whether or not it's a document that applies to this matter, given this matter is a
All right.
A criminal proceeding.
All right. I understand.
Civil proceeding. So there's that issue.
All right. So in terms of, but you admit, you're prepared to accept that it was served on you on or about the 15th of July, Intrasected.
It's against your rights.
Yes, thanks, Mr. Ansell. And there was no notice to dispute that was filed. Mr. Ansell, I understand you.
No, Your Honor. He didn't hear that. He's confused about it. He's asking me what you were saying.
Mr. Kuksal.
I'm clarifying for the record.
Mr. Kuksal.
He was asking me, Your Honor, what you had said.
Yes, all right. You accept.
Your Honor, my understanding of what you just said was that we note that the document was served on us.
Yes. Down.
And then I responded to say that we don't accept the notice to admit as being a notice that's in this jurisdiction.
Yes. Look, and this is what I understood you to be saying.
Yes.
And I didn't see any ambiguity in it at all. You accept that the notice to admit was served on, or it...
Yes.
About the 15th of July, burst or devoir.
Yes.
But you intend to argue that it's effectively ineffective, because this is a criminal proceeding, not a civil proceeding.
Yes, correct.
Thank you. Hey.
So we don't concede any of the points, obviously, in that notice to admit.
Well, that depends on whether it takes effect.
Yes, Your Honor.
Yes, thank you. All right, now yes.
On that basis, Your Honor, firstly, Rule 35.07 restricts the effect of admissions only to this proceeding. And of course, Your Honor can give judgment on admissions under Rule 35.04.
When I was looking through these materials, I was conscious that, as I've mentioned to you the other day, it's important to bear in mind that Mr. Ansell, to the extent that he's dealing with matters where he's a party, is entitled to be a witness in his own cause, and to write correspondence on his own behalf. In that context, the thing that seemed to me to be the high point of the matter, that is, something which would require some explanation about why it wouldn't be engaging a legal process, is the bill of costs, and the affidavit.
It would be.
It might be I'm not sure if the exhibits
IF0, IFC06. It should be, Your Honor, and that's as exhibited to the affidavit of Isabella Cesare, which was affirmed the 21st of June 2024, which I would also read.
Yes, so is that the high point?
It is a stronger point, yes. So that is the first matter of 4 against him. The second is the issuing of the correspondence of a legal character on behalf of others.
Which, all right. So, Rasalison?
Not just himself.
Look, I understand your point about the affidavit sworn the 16th of June, where he says, I swear this affidavit in support of Mr. Kuksal's application to fix the quantum of the costs. And he goes on and produces a bill of costs.
Yes.
Suggesting that between...
So it should be on page.
Certainly. But in the period after October 2022, Mr. Ansell had taken instructions from Mr. Kuksal and all the like and charged him.
Yes.
Fees for it, and so forth. Believing how. So what is the other matters that you say I should have regard to? Spetta.
So, this is the bill of costs, the drawing, issuing of the bill of costs. The second is the correspondence of a legal character on behalf of others. And that included.
Take me to an example of that.
Yes, so that, and can I just pause just to note, Your Honor, that includes a circumstance where he is not a party to the relevant proceeding.
Yes. Down.
So, Your Honor will have to turn up the affidavit of Ms. Cesare, and I think there was a transcription of her last week which did not do her name justice. It's Cecere. If Your Honor turns to P6 of Ms. Cesare's affidavit at paragraph 17. That refers to...
You say, Mr. Is it?
Ms. Cesare, yes. That is a document that was prepared or purported to be prepared by Mr. Ansell on behalf of...
The name is Isabella.
Isabella, yes.
But male.
No, it should be Miss Cesare. What am I saying?
Sorry, I thought you said Mr.
No, sorry, Miss Francesca.
Okay, yes.
Sorry, Ms. Isabella, abort.
That's what I thought. Right, all right.
Francesca Cesare.
I've got you. No, all right.
Apologies if I've misspoken.
Anyway, let's keep going.
Yes.
So I've got her affidavit open, which is 135 pages long, and there's exhibits.
So, if Your Honor... Yes. If Your Honor goes to P6 of the PDF document...
Yes.
It's a PDF document.
Subpoena to produce?
Yes. And then, down the bottom, is the start of paragraph 17.
Yes.
Your Honor, she refers to paragraph 10 above, and also Exhibit IFC 03.
Yes.
And then she goes on to also refer, over the page, to another document. Now that would take, I would have to seek to take Your Honor through to those 03 exhibits, and those 03 documents, which are available, on the PDF form, from P50 onwards.
Yes.
So in the PDF form, at P50, there should be, in the top left-hand corner, IFC 03A.
Yes.
Which is an email, at the middle of that page, an email that has been sent through to the Supreme Court. And then, over 2 pages, to P53 of that PDF document.
My copy of that page is pretty poorly printed. But, from Ben Davidson to Isabel Cesare.
That's right, yes. We can hand up a hard copy. I'm not sure if Your Honor prefers hard or electronic copies.
I prefer electronic, but I could. Well, we'll just put up. My associate put up P50 of 135 of that affidavit. Can you see what I mean?
Yes, that's the correct document. And then if you...
All right, my copy, for what it's worth, is not as clearly able to be read as that, oddly enough.
Well, you delivered it on.
There has been some distortions in some of the letters. It must be something that has happened as I opened it.
Then, if we could just scroll through to PDF P53.
Yes, that's the plaintiff's cost submission, yes?
That's so, but Your Honor will see that this is a matter that's in the Supreme Court of Victoria, proceeding No. 04808, in which Mr. Ansell is not a party to that proceeding. And in the tram tracks, my words. In the tram tracks, it's purported to be filed on behalf of the plaintiffs to that proceeding, and prepared by Peopleshop Pty Limited, and the email reference there is peter@eruditelegal.com.au.
So that has got his email address on it. Is there anything else that indicates...
Sorry, how is that your email address? There's no evidence.
That it was prepared by Mr. Ansell?
No, just that. And then...
How do I know he wasn't a party?
Well, Justice Janane has published judgments in that matter, and Mr. Ansell is not a party.
So it's a matter of public record?
Yes.
Yes.
And then from...
So you say the inference is, from the email address, that this is a document that has been prepared by Mr. Peter Ansell?
Yes. And he's preparing documents of a legal character for...
Other people?
That's so. And then if Your Honor, if the PDF document is able to be scrolled through to P55...
You don't have it. I mean, I do have it in copy. It was just that one page where something had gone a bit wonky. This is all perfectly fine.
Yes. Okay. Then I can move quicker then, Your Honor. So this is Supreme Court Proceeding 03994, your affidavit, MSU, and the email reference there is peter@eruditelegal.com.au.
He's a party in this proceeding?
He is. Yes. I accept that.
So what's she done wrong here? Assuming that I infer from the email address that Mr. Ansell prepared it, and presumably Mr. Ansell is, at this stage, the only director, I think, of Peopleshop Pty Limited.
That's so. Well, I would say that that this is a document of a legal character, and the inference is that he has prepared this document.
For Miss Zhu?
For Miss Zhu.
What happens if you'll bring action, somebody sues a husband and a wife and a child, right? And they're not legally represented. And the husband swears an affidavit saying, I swear in this affidavit on behalf of my wife and child. And the husband types it up.
Yes, I hear what Your Honor is saying.
Would you say that that husband is engaging in legal practice because they are preparing a legal document? It's a problem. It's difficult, isn't it? When somebody is a party.
It is.
And you've got 3 people or 4 people who purport to have a common interest, and one of them doing documents that they're all relying on.
Yes, I accept that that is a difficulty. It is the way in which this case is put, is not one by which each or any individual document should be viewed in isolation either. It is, as I'll take Your Honor through certainly, particularly in Exhibits 3 to Mr. Cherry's affidavit, they should be seen in a context against each other. So if, Your Honor, for example, turns over the page to P56. This is an email that's been sent to Your Honor's chambers on the 17th of May 2024, where Mr. Ansell attaches an unsworn affidavit on which the plaintiffs will rely in support of their foreshadow application to the proceeding. And it's a signature, there is certainly his name above lawyer.
Yes. Which proceeding is this? A proceeding which he's a party?
So, over the page it's 04028.
Yes.
And yes, he is a party to that proceeding.
So why isn't he like the husband in the situation I gave, saying, most of these cases happen when the person who is engaging a legal practice is acting for other people, but not a party to a proceeding themselves?
Well, Your Honor, if Your Honor turns over the page to P57, this is the affidavit of Mr. Ansell. The date is the 17th of May. It's filed on behalf of the plaintiffs prepared by Erudite Legal.
Yes.
And the email there is the Ansells. So he's purporting to, in my submission,
he says I'm the 5th plaintiff, and the sole director now. He's allowed to give evidence in the proceeding, and he's allowed to swear an affidavit in the proceeding, and he's allowed to type up the affidavit that he swears in the proceeding. Iskaiko mun.
Yes, I accept that, Your Honor. What's happening here in the tram tracks, however, is he's purporting to indicate in my submission that this affidavit is being prepared by Erudite Legal, and he's the contact reference. And of course Your Honor will know from the affidavit of Mr. Anstie that Erudite Legal was the trading name under which.
So what would your argument be if between the tram lines it just said prepared by Peter Ansell? And Nate?
If it had said prepared by Peter Ansell, it would be a very different argument.
Well, would you say then that this engaging in legal practice or not? Hasei Hokowerson.
If it was an application that was being filed on his behalf, I don't think I could.
This has been filed on him and the other parties.
Yes.
Are you saying if he said, I'm one of the parties, here's an affidavit that everybody wants to rely on?
Then I think it would turn on the nature of the application and who was running it. But certainly if that was the case, I wouldn't be able to argue that he would not be able to swear or give evidence in such a proceeding. So an affidavit would give evidence in such a proceeding. That's not what is happening in that affidavit. And then, if Your Honor turns through to IF, it should be page just before IFC through E. I just lost the page number reference, if Your Honor will just excuse me a moment. So it should be P69 of that PDF document. It's a document again filed in this proceeding 03994 submissions made on behalf of the defendants. The date of that document is the 22nd of November 2003. And again that's been filed on behalf of, it says there, the plaintiff.
Again, he's a party.
Yes, I accept that. But it's prepared by Erudite Legal being.
So if he said submissions, made on behalf of the second defendant, and he wrote, prepared by Peter Ansell.
Yes.
Would we be here?
No, I would expect not, Your Honor. But the difficulty is, of course, that we can't. In my submissions, it's not to be the case that we will, or the court should pass or separate out this evidence. What we have here, for example, when I took Your Honor through to that email before, there's of course that email under which Mr. Ansell has his name, and then has beneath its lawyer director. And of course, delivery of Erudite Legal as it was then just a law practice. So seeing these things together, and for example, if we turn through to YFC03 FANG, Your Honor turns over to P74 of the PDF document. Again, this is a separate Supreme Court proceeding, 04028. Quits.
Sorry, Ba.
A different one to 03994. 04028 is the proceeding number.
He's a party again to that, isn't he?
Yes, and the subpoena, There's a subpoena to produce prepared by Erudite Legal. Email peter@eruditelegal.com.au. Alof hacks.
But as a party, what are you meant to do? If you're a solicitor without a practice license, and you're being sued, and you want to issue a subpoena, what are you going to do? Are you going to draw up a subpoena?
But he's drawing up a subpoena that's purporting to be prepared by Erudite Legal, a law practice.
No.
That's the problem. It says right there,
The question is whether he's engaging in legal practice.
Yes.
Not whether he's making misrepresentations or the like, is it?
In my submission, very clearly preparing court documents, affidavits, submissions, a subpoena to produce, does fall, or very close to, the height of legal practice.
No, I agree.
Yes.
But that's to be, and I don't quite know what the answer is to this issue, but there's something very different for somebody doing it, for parties who are being sued from somebody doing it, who is himself being sued, along with a group of colleagues.
Yes, I accept that, Your Honor.
What's meant to happen? Suppose the zoo says, well, I'd like that subpoena as well, can I use the form of subpoena you've used? Does Mr. Ansell just have to, look, sorry, if I drew a subpoena for you that would be engaging in legal practice? It gets a bit silly, doesn't it?
In that circumstance, I would accept that. But what on the face of this document is just something different?
Well, the Erudite Legal is
It's a business, that's all it is.
Mr. Kuksal, please? The Erudite Legal is jarring.
Yes. Who made?
Because it should have said, prepared by Peter Ansell.
Indeed.
If he's really preparing it in his capacity as a party to the proceeding, he should say, I've prepared it.
Yes, I accept it.
And instead, it looks as if it's been, at first blush, been prepared by a law firm.
And that is the case. Well, that is what we say should be the inference to be drawn.
That's what I'm trying to think about. Whether is your beef about that he's pretending something that isn't true, or is your beef about that he's engaging in legal practice? To speak using beef as a colloquial.
Yes, I accept what, Your Honor. I understand, taking these documents at their face, that they are being prepared by Erudite Legal, that law practice, as it then was. On its face, Mr. Ansell is engaging in legal practice by preparing these types of court documents. That's what we say is the inference. I say is the inference that should be drawn. It's not the case where he is merely seeking to prepare these types of documents on his own behalf, or indicating that he's preparing them as a self-represented litigant, which might also be relied upon by another party, whether or not it's another represented or self-represented party. The flavor of these documents, along with those emails, for example, that email I took Your Honor to, which displays the livery of the law firm, does, in my submission, support an inference that Mr. Ansell here is engaging in legal practice. He's holding himself out in my submission. These documents are showing on their face that they've been prepared by a law firm, a legal practice. A legal practice.
Yes, I think I have to reflect on that. I can see the attractiveness of your argument, but I'm not sure whether it's just a superficial attractiveness that says, here's a document that purports to be prepared by a law firm, through Mr. Ansell, who at the time is the only director.
Yes.
He didn't have a practicing certificate, therefore Erudite Legal or him is purporting to engage in legal practice, but it's got a wrinkle when he's in fact relying on it in his capacity as a person being sued or suing in his own name.
I accept it's not straightforward, Your Honor. I certainly accept that.
But that's why I thought the invoices are a different category, and you'll probably come to them in a minute. The witnessing of an affidavit.
Yes, I'll come to that in a moment. And so that's where, and, Your Honor, I have skipped over them, but I don't mean to take Your Honor to them now. But of course, those exhibits under IFC 02 are also other examples by which Mr. Ansell is communicating with the court, and also again, using the livery of Erudite Legal.
Yes. Adert.
Now, turning through to P76 of the PDF version, which I hope I have right, this is 76, and then over the page to 77. Firstly, at P76, Your Honor will see a separate proceeding in the Industrial Division, in the Magistrates' Court of Victoria.
This is the proceeding.
Yes, Ms. Lauren Reddy is the plaintiff, and People Shop Pty Limited, there is the defendant.
Sorry, what page are you on?
It should be PDF, P76. Medi.
Sorry, I'm on the yes.
This is a document purported to be prepared by People Shop Pty Limited, and this is the affidavit of Mr. Ansell.
Right. So, People Shop has been sued.
Yes, and an affidavit has had untidges ka.
He's a director without a practicing certificate.
That's so.
And he puts in, is it the same thing? It says prepared by Peter Ansell. He'd be entitled to put an affidavit, to prepare an affidavit like this, wouldn't he? And to swear it?
Well, he would be entitled to swear an affidavit, yes, for a party in a proceeding.
No, for himself.
Or for himself.
He can give evidence on behalf of other people. The CID.
Of course, yes.
Your Honor, I wish to clarify.
I'm not interested, Mr. Kuksal. You just...
No, I'm an interested party in that proceeding.
Mr. Kuksal, I'm listening. Just please sit down.
He had the court's permission to represent the firm, not as a lawyer, but as the self-represented director.
Mr. Kuksal, please, take a seat. I'm not interested in...
This is misrepresentation, Your Honor.
I'm not interested in hearing from you.
And Mr. McAuliffe was personally acting for the...
If you keep interrupting, I'll have you removed. I'm not going to have you disrupt Mr. McAuliffe.
I'm not disrupting. I'm taking an objection. He's presenting evidence.
Okay. One more speak.
I'm a party in this proceeding, and I'm objecting to the giving of evidence because Mr. McAuliffe has acted in that proceeding. He knows that the magistrate has given Mr. Ansell leave. It's a proceeding in which directors are allowed to represent companies. It's in the industrial division of the law court, and Mr. Ansell has clarified to the Magistrate Fawcett, that this is the issue, and Her Honor knows.
Your Honor, I object to this. I'm in the middle of my case.
Yes, just sit down, Mr. Kuksal. Let Mr. McAuliffe present his case.
Are you overruling my objection?
Yes. I'm just asking you to sit down, because it's not an objection. It's a submission and an argument.
But it's to the adduction of evidence. I'm objecting to the admissibility of the evidence.
Mr. Kuksal, the affidavit is in evidence, a warrant.
It's not yet in evidence, Your Honor. It's the first time.
Mr. Kuksal, I'm not hearing objections from you. I'm making findings in an application for an injunction against Mr. Ansell.
It's a common proceeding.
Enough. I've made my decision. I'm not...
I haven't had an opportunity, Your Honor, to address the admissibility of their evidence.
Mr. Kuksal, I'll have you removed from the proceedings.
You can do that. At least it'll be clear for the transcript that I wasn't given an opportunity. I'm taking an opportunity for the first time to object to the admissibility of the evidence.
All right. So, you object to the admissibility of P76 of PDF of the affidavit?
No. Of the whole affidavit, and I have different grounds. But this particular ground was so prejudicial that I didn't want you to be exposed to it without context. I've not had an opportunity to address the admissibility of the affidavit. We have previously questioned the admissibility of affidavits, and we've not been heard about the admissibility of these affidavits.
Mr. Kuksal,
Your Honor, there are other grounds of inadmissibility that I want to raise, and I've not been given the opportunity to raise the admissibility argument. This is the first time that it would be...
Yes, you weren't ordered to give notice of it, I suppose. You've not put any affidavits in yourselves, have you?
Your Honor, we made another application. We didn't say that we didn't want to put evidence.
Is this affidavit in the notice to admit?
It is, yes.
It's admitted, Mr. Kuksal. Hutisman.
Your Honor, we had made an application to the court to have the notice to admit be struck out.
Mr. Kuksal, you can run your argument. I'll have to decide whether the notice to admit is effective.
Yes, but the problem, Your Honor, is that we did not respond. Your Honor, if you could just hear me.
No.
But you can't admit evidence in a proceeding.
Mr. Kuksal.
Which?
You expect to be able to take over and run this proceeding as you wish.
No, that's...
You demand to be heard.
A blatant mischaracterization.
You demand to stand up and for me to sort of...
You have to hear.
I am letting... These documents have been provided in a notice to admit, and if the notice to admit applies, then they're in evidence. Right?
No, Your Honor. That's not the so. May I be heard about my understanding of the law? We are raising a preliminary argument about the admissibility or the operation of the notice to admit. The notice to admit applies an intention to take a specific step. Now that intention...
Mr. Kuksal,
Your Honor, you're not letting me complete the argument.
I'm interrupting you. You can make this argument at the end.
No, but this should not be admitted.
I'm going to let it, provisionally admit it, subject to your objection.
Okay. May I be heard about that?
No, you can't be heard. I'm not going to let you disrupt Mr. McAuliffe's attempt to present the case.
Your Honor,
You can make your argument. I've reserved your right to make your argument on admissibility. Please sit down.
okay. Just one thing I want to clarify.
No, Mr. Kuksal.
May I get a ruling about that, please?
No, Mr. Kuksal. Sit down or I'll have you removed.
I'm sitting under protest.
Mr. Kuksal.
Your Honor, I'm sitting under protest. But,
Sit under protest all you like.
no, but I'm clarifying that.
Mr. Kuksal.
I haven't been heard about the questions
Mr. Kuksal. Headed piece.
of the Evidence Act.
Sit down. I think we proceed on the basis that the documents in the notice to admit are kafar,
Provisionally relevant, Your Honor.
in evidence, but subject to the defendant's right to submit that the notice to admit is ineffective.
Your Honor,
Yes. Forholdsmiddelreis, detection.
that's a different thing. Sorry, that's a different thing. Because,
Well,
may I clarify one thing?
and if they are, well, what, Mr. Kuksal?
So my understanding of the law is that,
No. I'm not interested in your understanding of the law.
okay. So I'm saying that this is how it should be then. That the first issue is whether they are admissible. Then we should have an opportunity to address it. Because otherwise we never had the intention to make any admissions.
Your Honor, I object to this.
Sorry.
No. Sit down. Maska. Mais.
Your Honor made.
Mr. Kuksal, sit down. I'm not interested in.
Your Honor, we raised this issue
Mr. Kuksal. Hajat.
before the expiration of the period. To clarify, we raised this. The transcript will show that we raised this issue before the expiration of the period.
Your Honor, in Your Honor's orders. The data.
And it's because the court,
If no notices of dispute were put in, then the rules operate unless I'm persuaded to. Ingezer,
no, but Your Honor,
you can persuade.
there's another argument then.
Mr. Kuksal, stop talking over me.
Okay,
Mr. Kuksal, sit down.
I'm not talking over you,
Mr. Kuksal,
but let me just,
sit down.
you're making a ruling about it.
Mr. Kuksal, sit down or I will have you removed.
Your Honor, can you not?
I will have you removed, we will go online, and you will be muted, if need be. Repro Genbi is.
I'm not going to come online.
Mr. Kuksal.
No, you can kick me out. That's a different matter.
Are you going to sit down and listen, or are you going to keep standing up and interrupting? Hey, feeling.
I do not have the intention to interrupt. How can I interrupt? I'm just clarifying something that I don't understand.
No. Gosef Molthea, Golenins.
You're saying stuff
I'm telling
that I think you cannot say,
you. Stay.
and I'm clarifying if you actually mean to say it.
I'm asking you to sit down, and I'm saying,
Okay, Mitney.
I am not going to engage in any further dialogue with you.
You
Mr. McAuliffe is presenting his case.
couldn't know what I'm saying. Sorry, let me just,
Mr. Kuksal, no.
can I clarify one thing?
No, you can't. I'm going to adjourn. Let's stand the matter down for 5 minutes. And when I come back, Mr. Kuksal, you either sit down, or you will be removed from the court.
Your Honor, may I just leave? Sorry.
Thanks. What I might say, Mr. Kuksal, is, I'm hearing at the moment, the application as it concerns Mr. Ansell. I will reserve to you and Miss Shu the right to argue about the admissibility of documents as against each of you two, should you wish to do so, in due course.
No, but Your Honor, these documents are documents that are, you're deciding issues of fact. If you need to hear me about this,
No, I don't.
you can't, because you cannot presume what I'm going to say.
No, I don't, Mr. Kuksal. Hertis and
You don't know what I'm going to say?
Mr. Kuksal, I know that the effect of allowing you to talk will be further to disrupt the orderly hearing of this matter.
How do you know that?
I have told you that I am reserving to you and Miss Shu the right to argue the admissibility of this material as against each of you two. That is sufficient.
But you're deciding issues of fact in this proceeding.
Mr. Kuksal, just appeal. If you say this is all wrong, appeal it. This is I am trying to manage this case.
No, but I have an obligation right now.
Mr. Kuksal, that is what I have decided. So please take a seat, or I will have you removed, and we are going to proceed with the matter against Mr. Ansell.
Let me clarify one thing.
Take your seat.
Your Honor, I have a right to get reasons.
No, Mr. Kuksal, you are very strong on your rights, and you are a bit short on your obligations.
No, my rights are my obligations as well, in a lot of circumstances.
You have also got an obligation not to disrupt the orderly conduct of this proceeding.
And I am not doing that at all. What? I am trying to help the court.
I think you are. And I am trying to hear,
You are presuming that I am. You are presuming that I will, because currently I am not. What I am trying to do is point out to Your Honor that maybe Your Honor is overlooking the fact that if Your Honor, for instance, decides, take one of those documents for instance. If Your Honor, for instance, decides that that document was prepared by a legal practice, then Mr. Ansell is not the only officer of that practice. I am a corporate officer of that practice.
Are you a director of People Shop, Pty Limited?
I have some responsibilities that are...
Are you a director of People Shop, Pty Limited?
In some circumstance, on some occasions I have been...
No, listen.
No, during that period I have been. Your Honor.
Mr. Kuksal, I have had enough. Just sit down.
No, but you asked me a question. Let me answer that question.
No, I asked you whether you...
The fact is that when Mr. Ansell is unable to do some responsibilities, he defers to me.
Mr. Kuksal.
Your Honor.
You are proving my point, because you are disrupting. It is now 10-4. Hedis Rabunian fewer question citus on chate.
You asked me a question.
Yes, I asked you. You asserted that you were some...
I am an officer of the company, and I have directorship responsibilities on some...
Mr. Kuksal, I have told you what I have decided. I have decided that I am not going to hear from you anymore, and I am reserving to you and Miss Shu the right to argue the admissibility of any of this material in the claim, insofar as it concerns each of you two.
No, but what will happen to the issues of fact?
That is what I have decided.
Let me clarify one thing.
No, I am not interested in hearing from you anymore.
But you haven't thought about this.
Mr. Kuksal.
Your Honor.
Mr. Kuksal, this is my court, not your court.
Well, Your Honor.
I decide.
It's not your personal court.
Mr. Kuksal, I decide when you talk and when you don't talk.
Judicially, yes.
Yes.
But I am required to help you in.
And I am deciding that now.
I am trying to help you in deciding that, judicially. What I am saying is that...
Mr. Kuksal.
How will you decide an issue of fact? Will you then reconsider decided issues of fact when it comes?
Your Honor, I object. Mr. Kuksal is making submissions.
Look, I am not going to engage in this dialogue with you. I have told you what I am going to do.
No, I am clarifying one thing. So if you decide...
Sit down. Sit down, or I will have you removed. Eated.
Can you make an order?
No, sit down. I am not.
May I ask? Though...
No. Consora words.
May I make an application?
No, you may not.
To have you make an order.
No, you may not. No, you may not. Sit down. I am trying to proceed with this case, and this dialogue is wasting time. Sit down, or I will have you removed.
Can you stay the proceeding as it concerns me then?
No, Mr. Kuksal.
Because right now, under the law, I would be expected to raise a, you are placing me under tremendous prejudice.
Mr. Kuksal, sit down or I will have you removed. It is as simple as that.
Okay.
We have got 20 minutes.
Your Honor, is the effect of what you are saying that the proceeding is stayed as it concerns me?
Mr. Kuksal, I am not going to engage in any further discussion with you. I am trying to hear the case against Mr. Ansell. If you do not sit down, I will have you removed.
But you are deciding issues with...
No buts, no ifs, no buts. No further discussion. No for OI.
Your Honor, I would like you to make an order removing me then, because what you are trying to do is placing me under tremendous prejudice, because I do not know when to raise an objection, and whether, can you make a ruling that effectively stays the matter against me? Because then it is not that I would be expected to raise objections. Right now what you are doing is putting me under tremendous prejudice.
Mr. Kuksal, I acknowledge that I am stopping you at the moment from raising objections to issues of evidence. All right.
Which will decide issues of fact in this matter.
So to the extent that you say that has caused you prejudice, that is now on the record, and you can rely on that, if need be, and use from minere.
So you're expecting me to clarify for the record too. I will not give up any right.
Your Honor, we are wasting time. If Mr. Kuksal might be removed, we are this.
No, sorry, can you? I am addressing the court.
I am.
Mr. Kuksal, sit down.
Your Honor.
I do not.
I just want one clarification, and I will sit down after that. Just one question.
I think what I am going to do is I am going to adjourn the court now till 10:30 tomorrow morning. We are going to proceed by Zoom and...
Your Honor,
Unless Mr. Kuksal sits down. I mean, if I get him removed, that is going to lead to further argument this afternoon. It is 5 to 4. Thalagwind.
If Mr. Kuksal is able to sit down, and we can proceed with the time we have today. I apologize, Your Honor, but I am.
Mr. Kuksal, will you sit down, please? Are you sort of daring me to make an order to get you removed to try and provoke
Your Honor.
No. Can you... He's asking me, can you sit down?
No. I withdraw the question.
No, Your Honor, that was a most improper question. I have made it very clear what my problem is.
You are speaking in an aggressive, bullying and hectoring tone.
That's just how I talk. You know that by now.
No, you don't always talk like that.
When I am agitated.
Sometimes, Mr. Kuksal, you are very charming. You are dull and feeder.
But, Your Honor, you
know that...
I would like to hear more of that, but unfortunately I don't. The problem is, Your Honor, I feel this case, the way it is proceeding, creates uncertainty for me.
Okay.
And what I don't want is to contribute to any prejudice that I may face by waiver.
Mr. Kuksal, I am sure. Okay. I will put you at ease. I am not going to assume that you have waived any rights.
Not you, the Court of Appeal.
Okay. Well, you are on record about that, and you are just going to have to live with that uncertainty. Enter.
No,
Yes. Order thise.
So what I want, I am trying to mitigate that uncertainty to the extent that I can. And what I am suggesting to the court, is that one way of doing it, is if you, effectively, stayed the proceeding in respect of us or separated the proceedings. That is the proper way to go about it. Because what you are in fact doing is deciding issues of fact, which, once decided, cannot be reheard. Now, once you have decided an issue of fact in respect of us, we are stuck with that.
So a solution would be for me to just now treat this as a separate proceeding against Mr. Ansell, and that
is the only way to go.
And the proceeding that is against you and Ms. Shu listed for...
Yeah, what you are trying to do is basically unlawfully achieve that effect. If you wanted to do it properly, you would have, Wex.
And if...
I should have made an application to separate the proceedings, and that is the only lawful way to go about it. And then you have to decide whether that should be done, but you can't at one.
And so you would not consent to that being done?
Why would I consent to that? I would want to be heard about that. But the problem is that you can't...
Okay, I understand. Or confie. Foreshadowed.
No, you. Hereta.
I thought you were offering an immediate solution. You are offering something that could be done, that could then be the subject of further argument about whether it should be done.
I don't even know what you're saying, but what I am saying is that if...
Mr. Kuksal, show me height.
I am not conceding any ground. If you want to make an order separating the proceedings without hearing me, that's up to you. But I am not going to concede that. What I am saying is you should at least do that. Mr. Kuksal, I am not going to do anything, I am afraid, except ask you to sit down. Now we are going to see if we can use the last 15 minutes. I am an advocate. Your Honor, why would you not separate the proceeding against us if you are actually doing that? Why wouldn't you?
Because, Mr. Kuksal, you have not asked me to do so. You have said that.
Why would I do?
Stop. You have said that is what you could do. If you are going to do that, I will then have to be heard on whether you should do.
No, Bruce.
And now you are saying, why don't I?
Let me clarify. I am saying you are effectively doing that. When pardon?
You are asking me to do that.
No. To clarify.
Mr. Kuksal, are you asking me to do it or not?
No, Your Honor. If you let me answer that question.
Yes or no?
I feel like you are trying to get me to say something.
I am trying to get a yes or no answer. Are you suggesting that I should separate the proceeding?
I am asserting.
Yes or no? Weebway.
Let me complete, please. I am asserting that that is the effect of what you are doing, and you should be honest about it by making an order. Because that is the effect of what you are doing. You can't kick me out of my own proceeding for wanting to raise an objection to the admissibility of evidence. If you want to have the jurisdiction to be able to do that, without hearing me, then you need to separate the proceeding. You are effectively doing that, but you are doing it in the most improper, where a future court of appeal may come along and say that, you do not know, what the judge would have done if he had heard this. He was only upset with you because he thought that you were going to continue with the previous argument. If he had known that you were going to say the new thing that you could have said, so you don't know the arguments that I will make.
Who is you? Me? Fred.
No, that was the Court of Appeal judge in that scenario, addressing me. E2x.
Aretor lados ofide wonderia, sir. An mopel said the zo macrocraption follow blabin.
So what I'm saying is that, if Your Honor, for instance, is working with the impression that the argument that I have previously.
Your Honor, I object to this. We're going on.
Okay. Decido só francês.
My submissions? To go a cabo.
Yes, no, I'll agree. Okay, Mr. Kuksal, we'll deal with it again tomorrow morning. As far as I'm concerned, you're reserved all your rights. Let's use the next 15 minutes. Sit down, please.
I want you to make an order.
Mr. Kuksal, sit down, please.
So what's happening with the admissibility?
Mr. Kuksal, sit down, please.
What?
Sit down.
Your Honor, returning to my case, we have, if I might just raise the matter of housekeeping. I do apologize.
Sorry, Your Honor, Mr. Ansell.
Sit down, please, Mr. Kuksal.
I want Mr.
I'm not interested in hearing from you again in the next 15 minutes, Mr. Kuksal.
Peter, not you.
We're having conscience.
Your Honor, if I might just raise a matter of housekeeping for us all, just to consider very quickly.
Yes.
I do sincerely apologize, Your Honor. I'm part heard in a matter involving evidence in the middle of cross-examination of a witness tomorrow.
Well, this case is continuing tomorrow. I mean, this is set down for today, tomorrow. Tomorrow.
No, Your Honor.
Wasn't it?
No. Casus Morhojan's case.
I understood it was set down for last Thursday, Friday, and today, being Monday.
But this case doesn't operate by picking a day here and there to try and fit the convenience of counsel. The basic idea that a case, particularly a case like this, when it starts, it continues, not one is but not rain quality, not one is por as 12 head, when in the bind diwa. The bind dx if you will tease were a point, to rix. Not one is point.
Yes, I accept that, Your Honor, but unfortunately, we didn't use Friday.
Correct.
And I had not understood and had not made preparations to deal with tomorrow.
Well, why not? I mean, I'm sorry to be grumpy, but what did you think was going to happen? This case would all be over in a day for sure.
My case would have been certainly, at least by today.
Yes, I know, but I hate the way this case.
Well, Your Honor.
What are you saying should be done?
Well, if Your Honor. Well, if the court and the defendants have availability on Wednesday, we could just commence, reconvene on Wednesday. Reconvene on Wednesday.
Well, I don't have convenience. I can't be here on Wednesday. Unless I rearrange everything else. Actually, no.
I apologize, Your Honor. I didn't hear that.
I've got commitments elsewhere on Wednesday.
Or Thursday. Or occurring for.
Thursday.
Well, I've got things on Wednesday, Thursday.
Okay.
I mean, these cases are set down with estimates. With
Yes, and the estimate was 3 days. 3 days.
But they are not set down as, it will go for these 3 days or whatever and then it'll miss and it won't continue. It's set down to be heard with an estimate of its duration. I mean, it's a very difficult situation that you're putting the court in now.
Yes.
Your Honor, I also have unavailability on the Tuesday, Wednesday, Thursday. I think I'm available. And then Friday, I don't think there is a hearing.
Trial, yes.
Well, Your Honor, I apologize to speaking over Mr. Ansell. If Your Honor wishes to proceed tomorrow, it may that there's another counsel, Ms. Norton, who's appeared before Your Honor previously, who might be available tomorrow. Those inquiries can be made quickly, but I'm not sure about her availability.
Look, I know it's a difficulty and I'm sorry that I wasn't as pleasant towards you as I ought to have been just now, and I understand that you would not have anticipated over the weekend that there would be this morning taken up with other matters.
Thank you, Your Honor, and I certainly...
I do have real sympathy for you but it is just a frustration.
I accept that, Your Honor, and to be quite frank, it may have been that potentially we could have just set this matter for longer, but
Again, you say set it down for longer. We're saying there should have been a longer estimate.
Well, solely, he worried.
It's not set down for fixed days.
Yes, then it may have been the estimate was incorrect, if this is the number applications that have been brought in the last 2 days. One of ways?
That's right. And look, I have got sympathy, because it did start some days ago and this has happened.
Yes, and...
Is it possible that Ms. Norton is going to be available, if I stand it down for 5 minutes?
Yes, if Your Honor could stand it down for 5 minutes, and we can...
Well, say it now.
No, I am told that she's not available.
I didn't hear that.
So the position is that you simply can't proceed tomorrow and there's no alternatives. So the matter has to be adjourned to a date that's suitable. Or is your client going to find someone else who can continue tomorrow? Do you want 5 minutes?
Yes, we'll need 5 minutes, Your Honor, to be able to make those inquiries.
I'll stand the matter down for 5 minutes, please.
Your Honor, Miss Shu is just returning. She was feeding the meter.
All right.
So yeah. Pasafroveri sureri.
Well, guiding. Gorton.
Yes, Your Honor. I think it was with me. We made inquiries. Unfortunately, at this stage, Ms. Norton is certainly not available tomorrow. It's such as.
Well, the obvious thing to do would be to just move the claim against Mr. Ansell, then to be reheard with the claims against Mr. Kuksal and Ms. Shu on the 20th.
Yes. Well, yes, I don't oppose that, Your Honor. There's just a number of issues. Firstly, I've already opened my case in relation to paragraph 3 against Mr. Ansell.
Yes, Uspolf.
So we might have some complexities there.
What?
In terms of how that would proceed, but I'm sure we can.
Probably manageable, though. Hurdisk.
Manageable. And then there might need to be an issue about the estimate on that date.
Well, Harawi.
It's the same claim, Your Honor.
Well, Mecca. Just in terms of,
I can tell you
if I need to keep that week free, I'll keep that week free, Your Honor, but...
Well, it's on the 20th. That's a Tuesday.
Yes.
And my expectation is when the case starts it goes until it finishes. Everberb.
Thank you, Your Honor.
It's not like there's 3 days, and then we come back in 3 months after that. The case is listed to start on the 20th of August. Or Tofiadot.
Yes,
Your Honor, I have a hearing on the 23rd of August.
Well, you had better deal with it, Mr. Kuksal. We had better hopefully get it dealt with by... It should be finished by the Thursday, shouldn't it?
Well, Your Honor, it's a hearing in which...
3 days should be enough.
It's a hearing. It's a criminal matter, and I can't actually. It's a bogus criminal matter, but it's a criminal matter nonetheless.
Well, we will cross these bridges when we come to them. But my plan is just...
But I have a duty to tell you now, so you don't think then, I should have told you beforehand. I have a 23rd is the date, right?
That's the Friday.
It's the Friday.
No, I received a notice.
Mr. Kuksal, the proceeding is already set. The proceeding, insofar as it concerns you, is already set down for,
20th, right. Yes, but you're saying that everyone should keep all the future dates available indefinitely. I'm saying, the 23rd. This is the first time you've said that, and I'm clarifying to you that I have a hearing.
It might be the first time I've said that. It's because it's not something that needs to be said. The understanding in this court is that when a matter is listed for trial, it starts, and it runs, and it finishes, and it finishes. Portsy.
What about the other hearings? The judges make the orders. They don't ask you. They don't ask you if the other hearing is likely to.
Well, that's you. People have just got to deal with it. But Mr. Kuksal, I hear what you say. I think that if the matter proceeds as it ought to proceed, any.
So that's 3 days, 20th, 21st, 22nd.
It should, yes. It should be over within 3 days. I mean, we've lost a large part of today with applications that were brought this morning, and the like. If we don't lose time in that way, I would have thought, things should be done on the 20th, 21st, and 22nd. If it ends up that final addresses have to be in writing, or something like that, we can cross that bridge when we come to it. Every along 20ec to it.
Thank you. It was simply for your benefit that I was telling beforehand.
No, they fas burst menonitive.
So you could plan.
Nothing improper at all about you raising that with me, Mr. Kuksal.
Yes. This are a lot.
And I'm not suggesting there was.
Because I thought that way, you can manage the...
Mr. McAuliffe, look,
Your Honor, I can't do anything.
I just want to say for the record that I acknowledge that this case was listed for hearing last week, and then not on Friday, and then I set this day, and I did that really, effectively, without consultation to you, so I'm in part responsible for putting you in this difficult position. And I just want to say I do acknowledge that,
I appreciate that, Your Honor. I do apologize for not being available tomorrow. I do apologize for any complications. And I just would emphasize that I certainly would have made myself available tomorrow. Except, I'm in the middle of cross-examination, which makes it impossible.
No, you were put in a difficult position when the matter didn't. But be that as it may.
Yes. Kura. Waskedan Frenul.
In terms of the recusal application, Mr. Kuksal, 10.30 tomorrow does seem a bit tight, I was giving that direction because I was anticipating we would be back here tomorrow, and I wanted to deal with it at the time. In the circumstances, we're not back till the 20th. How about if I say any recusal application to be made in writing by 10.30 on Wednesday, which is what you had asked for?
Yeah, that's workable. But I want to clarify one more issue, for everyone's benefit, beforehand, so it doesn't ambush anyone at the last minute. It's our position that the submission regarding the criminal nature of this proceeding had been raised prior to the expiration of the notice period, and it would be wrong for the court to rule that, if it finds that it's a civil proceeding, then we don't get the benefit of the notice. So what we suggest is that the court make a determination about that beforehand, so then we have the opportunity to respond to the notice. The provisions that apply for the response.
Hang on, let me just... So what? Just go, take me step by step. I make an order that any recusal be, by writing, on or before 4:30 p.m.
On Wednesday.
On Wednesday the 7th. And now you want to say that the notice to admit doesn't bite.
No, what I'm saying is, you have to decide beforehand whether, because...
But no, tell me what your argument is.
My argument is this.
No, don't present the argument. Tell me what the conclusion of your argument is. Regading.
Yeah. The essence is that when a party is served with a notice to admit, they make conscious choices, and those conscious choices can only be made if they have the understanding that they're working in a civil proceeding, and they would be bound. We do not have that understanding. The whole legislation presumes that acceptance by both parties, and we have here beforehand, pebist,
I don't understand. Just tell me what
we want the court to do.
Tell me what order you're going to seek.
Yes. So, the court should order or make its determination about whether it considers that the notice to admit, the use of notice to admit, will breach any of our rights to due process in criminal proceedings. And if the court decides, even on papers, although we would prefer for it to be heard properly, but so, we're not saying that the court should decide it on papers, but we're saying, in any event, the court should make it very clear that it considers the notice to admit be applicable, so we can then, within a short period, formally put our response, if we had to, because...
Well, mister, I start on the basis that the notice of the proceeding, notice to admit, is effective, unless someone persuades me. That's the ending persuades me.
No, because the party that makes a choice not to file a response is a party that makes a conscious choice, knowing that it's a civil proceeding, and that's the prejudice.
You are going to seek an order that the notice to admit is ineffective.
Because of the criminal nature.
You're going to seek that order. Hijazkates, there is a saying.
Yes, but what I'm saying is that
All right.
What their position is, that if it's not, then the court should presume that we chose not to respond to the notice to admit, and I'm saying that that's not a conclusion that you can draw directly, because it presumes an intention, and you know that we don't have that intention. So, Regading Gorton.
I don't know what your intention is, Mr. Kuksal. I will order that any submissions in support of an application that make it is not me on teen.
At least until Monday, Your Honor, because we're on trial on Friday.
Yes. That the notice to admit is ineffective in this proceeding be filed and served. Bert. Accused you have Accused you have Accused you a.
By Monday. At the earliest Monday, Your Honor. Miss Shoes?
Yes, by 4:30 p.m. on the 11th.
Monday is the 12th. 11th is Sunday. Ostensibly.
So it is, yes. The 12th of August, 2024, and Erudite.
I should note that Ms. Sue is objecting to that. That's my position.
Order that the notice to admit is any submission in support of an application that the notice to admit is ineffective in the proceeding be filed and served by 4:30 p.m. on the 12th of August, 2024.
Okay.
Yes. Pa.
And, again, speaking for myself, now from my perspective the court...
What does Ms. Shu, what's your problem with that? What, dear N?
Can I get 2 more days?
No, a week is long enough.
Okay. And can I just put the point?
They're on notice. The Sheila...
Yes. Berejust. Pistix.
Okay, thank you.
Your Honor, the second step, then, would be for the court to make a ruling about that, and then we should be given a short period to respond to the notice to admit, so we can...
But if the notice to admit is effective, then it's admitted, and they...
No, we need to know that it's effective for it too. An admission is, Your Honor, an intention. An intention.
No, it's not. It could be. You can accidentally admit. Failing to comply.
How can you accidentally admit to things under this particular process?
Because that's what notice to admit does. If you've got time to respond. If you don't respond, you're taken to have admitted. The verse point is given.
No, that means you have the intention. So, for instance, if someone was served, but the service was not effective, it doesn't...
Mr. Kuksal, you can put your submission in.
Well, you should then give us an order, and give us an opportunity.
And you will have to come prepared on the 20th, ready to argue on the basis that the BAP and you want is clever sheet. If you want is it.
Okay, but we want to... What is the problem? We're foreshadowing beforehand, and we want to file a response to it. What is the prejudice?
What's your response to what?
The notice to, if the notice to admit you find is effective.
Why, C's?
We should be able to respond to it.
Well, why don't you file a response to it now?
Because, Your Honor, because what? We will be giving them information that they could use against us in a criminal proceeding.
How is that?
The reason why we're not responding to it.
The notice to admit largely produces correspondence, doesn't it?
That's not the point. They're asking. They can't know.
Are you disputing that the correspondence was sent?
Your Honor, that's not the point. We're saying this is a criminal proceeding. You haven't decided if it is or if it isn't. Now, if it is a criminal proceeding, we're making admissions against ourselves. That's contrary to the right.
Well, you will put your argument in by 4:30 p.m. on the 12th of August 2024 that will address these matters.
Yes, but what we're saying is that if the reason why we haven't responded to it is that if this was actually a criminal proceeding, then we're making admissions against ourselves in criminal proceeding. So it's not that we, in the alternative.
If you admit it.
That's not the point. Your Honor, we should not be put in a position to respond until the court has clarified that this is not a criminal proceeding.
You could have denied Menchiurus Niwers.
Your Honor, can I? Hope, bar.
No, but that would be wrong.
Mr. Kuksal, you.
We can't lie.
Mr. Kuksal, you're going to put in a submission, the submissions you want in relation to the notice to admit on the 12th of August 2024.
No, but we're not going to provide a response in the alternative, because that's a breach of. Is that what you're expecting us to do, Your Honor?
Can I?
I'm expecting you to put whatever submissions you want to put in relation to that suggest that the notice to admit should not take effect in accordance with the Supreme Court General Civil Procedure Rules, 2015 by 4:30 p.m. on the 12th of August. On the 12th of August.
And then, if you decide that it should.
No, I'm not going to bind myself as to what I do or don't do then. I will read the submissions. Urjoin.
No, but will we get another opportunity to respond to the notice to admit, if it is effective?
You might, or you might not. You just, Kosfrig.
How can you conduct a proceeding that way? We should know what we're facing.
Mr. Kuksal, just.
How can we work with uncertainty? You're saying that we may or may not get a chance to respond to it.
Yes, that's correct.
So how do we plan the case, Your Honor, if we don't know whether we will or we won't?
Be ready for each alternative.
So effectively, you're saying that we should answer the dots.
Your Honor, if I can just seek to be included in that order, in relation to submissions about the notice to admit, and also seek leave to file any evidence.
Sorry. Say that again.
No, we oppose that.
I would seek.
I haven't even heard it.
Your Honor asked me a question today, in relation to service of the notices to admit. I would seek to be able to leave, to be able to put in affidavits in relation to the service.
An affidavit of service?
Affidavit of service, particularly because in serving the notices to admit there was a covering letter and also an enclosure of a copy of Order 35 of the rules, and I would seek to be able to put that before Your Honor.
I'll see those affidavits before I allow them to be admitted.
No, Your Honor. I have an objection to that.
Mr. Kuksal, just sit down, please.
Don't make the order before.
Just sit down, please.
Sure.
Other people have got to talk as well. Mr. McAuliffe, I'm still talking to Mr. McAuliffe, and you've just come in over the top.
I'm just saying, don't make an order.
No, I didn't understand there to be an issue that things are being served.
No, there's not an issue. I just wish to be able to put a more fulsome presentation about the manner of service, and also what else was given when it was served.
All right. Now, Mr. Kuksal, how could you object to that?
Okay. Because until you decide that this is not a criminal proceeding, we should not have to comment on the notice to admit at all, because it is against Konaitim Gorizagat.
Mr. Kuksal, that's not what's being asked. They're saying they want to put in an affidavit identifying what was served, with a notice to admit.
Okay. So, if the evidence will be only excluded. Sorry, only limited to this service proof.
It's 4.30, Mr. McAuliffe. I'm not going to make an order in relation to it now, but I invite you to prepare the affidavits and circulate them.
Of service.
Affidavits of service saying what? The affidavits you wish, and I'll deal with them in due course.
So no other evidence, just the evidence of service is what Your Honor is saying to clarify.
Mr. Kuksal, I'm not making an order on it either way, and I'm inviting them to circulate what it is that they wish to file, and when I've got that in front of me, we'll determine whether that.
But then we should be given an opportunity to respond.
Maybe you will, Mr. Kuksal.
Your Honor, I'm clarifying. To be perfectly clear, are you saying that we will not get an opportunity definitively to respond to the notice to admit?
What I'm telling you is that at the moment, there's a notice to admit that has not been the subject of a notice to dispute.
But we can't.
Mr. Kuksal, just listen please. You tell me that you want to run an argument that the provisions that apply in the civil procedure rules don't apply, with the result that the notice to admit does not take effect. I'm telling you, you've got to put submissions in support of whatever you want to say about the notice to admit. When the matter comes back for hearing on the 20th, I might not have yet decided that. You have to be ready to go, based on whichever way I might jump.
But that's not.
And if that's a problem, it's a problem of your making, not my making. Adjourn the court. This matter is being adjourned to the 20th, but just adjourn the court, scene die.